Good morning, everybody. Łukasz here.
Sveiki, laba diena.
Good morning, everyone. Let us wait for a minute and then we'll start.
Ladies and gentlemen, it is good to see you here today. We will wait one more minute and we will start our event. Manau, galime jau pradėti, gerbimieji ponai ir ponios.
Let us start, ladies and gentlemen. I'm very happy to see all of you here at our event meant to discuss the problems of national minorities. The situation of Lithuanian national minorities in the context of Lithuanian and international framework. I do hope that you hear me well. If you have any problems, then please talk to me and we'll deal with all of them. Well, the conference was organized on the occasion of a 10-year anniversary of the European Foundation of Human Rights. So these are the 11th years already. Back in 2010, we established our foundation, and quite a lot of things and projects have been organized throughout all this time. And we have been cooperating with Lithuanian and international institutions. Let me welcome our speakers today, as well as our guests. The representative of embassy, Emina Szmalec of the Polish embassy, Artur Ludkowski, advisor to the Prime Minister on national minority issues. We will ask Honorable Councillor from the embassy to say a few welcome words. We've been cooperating for a number of years, and I'm very grateful that you could join our event. please turn on your mic because we cannot hear you. Good morning. Thank you very much, Councillor, for your introductory speech, for your wishes. Thank you very much for your comments. Indeed, we will speak about problematic issues of national minorities. We will speak about the, as you've mentioned, the problems of education, also the spelling of personal names. I do hope that we will be able to reach constructive decisions and ideas. Now, I would like to give the floor to our guest, Artur Witkowski, advisor to the Prime Minister on the issues of national minorities. Good morning, organizers, speakers. I'm very happy to welcome you on behalf of the Prime Minister. She passes on to you great best wishes. Well, I do know all the problems as an advisor. I work for 20 years on those issues. As regards legal situation, the law on national minorities, we have initiated this law some 3 years ago with the previous term in government. And I would like to say that the approach has been changing. It lasts for a long time to change the approach, but Mrs. Dobrovolska, the Minister of Justice at the time, at the moment, used to be the working group member, so she helped to draft this law. Well, its adoption in the parliament and discussion in the parliament is lagging behind. I do hope we'll be able to approve it. And I also hope that we are a mature society. And the approach on national minorities is changing. Last week, I visited Georgia and I talked with Azeri and Armenian national minorities. there they are considered as a threat. I believe that if we understand and perceive national minorities as a treasure, not as a threat in the country, then the approach is changing. I do hope that the law on national minorities will be adopted this year, and as well as the law on spelling of personal names will hopefully see the parliament in autumn. And in the last 3 years, I've seen that the situation has not deteriorated, and I do hope the situation will only get better. Thank you. Thank you very much. Artur Litkovsky, advisor to the Prime Minister on the issues of national minorities. Yes, indeed, this conference was organized timely because of that, because the presentation of national minorities draft will be presented to the society. The society is discussing a lot. We would like to show a wider perspective, not only what the national minorities are aiming for in Lithuania, but also how the legal regulation in the global and European context looks like on national minorities. Our speakers today, who are the representatives of national minority institutions, will provide for a better perspective that will help Lithuanian society to focus on the fact that the problems in Lithuania of national minorities are important and relevant in European context as well. And that the rights are well-founded and they are important. Let me very briefly present the 10 years activity of the European Foundation of Human Rights. As I pointed out, we are focusing on human rights. We also focus on national minorities. I do hope that you can see me well. I will share my screen. European Foundation of Human Rights is a non-governmental organization in Lithuania, established back in 2010, and it was established as a response to the human rights and minority rights violations and abuse in Lithuania. The main areas of activity is free of charge legal aid in cases of hate crime and discrimination. We also submit shadow reports. We draft national reviews and publications. We focus a lot on hate speech on the internet and its monitoring, as well as education and awareness raising of the society. Well, we also represent in courts on original spelling of personal names, experience discrimination, hate crimes. We do receive quite a lot of requests. Every week we receive requests from the public. At least a few individuals address us who face the problems of writing of personal names. Most often these are individuals who are married foreign nationals and who experience a lot of problems. Here we're speaking about the situation of women most often, who face everyday situations because their last name was not written properly. Let's say they're married a foreign national, and in her last name there are letters such as W or Q that are not in the Lithuanian alphabet, and they are written in a phonetic way, and people face problems in the documents of children. Such writing continues, and then we have a family with different names. So we do receive a lot of requests for assistance of such a case, and we managed to achieve 15 positive decisions. If we continue on this topic, we are also trying to provide consultations. We also provide consultations in drafting complaints on hate crime and cases of language. We draft reports. Also active advocacy on the adoption of law on national minorities. We took part in the discussion in trying to talk about the concept of national minorities, and our representative took part in that working group to draft a new draft law on national minorities, which was actually drafted last year. We will be looking forward to the legal decision. As from 2015, we're providing support to persons that aim to implement their right to their name and private life, which are inseparable parts. Our victory was back in 2015 in the Vilnius District Court, when W letter was allowed to be written in the passport. That was a legal breakthrough. Such cases are still won via courts. You cannot do that in the civil registry office, but with such a precedent, with such a case, we can achieve a positive decision. Back in 2018, the court decided on original writing Jacquet. And back in 2019, Malgorzata was allowed to be written as Malgorzata in Polish because it's a Polish name. Also drafting publications. The newest is hate crimes and hate speech. The overview of situation in Lithuania is a very relevant publication about the entire situation in Lithuania, where we talked a lot with those who experienced hate crimes and discrimination. So it was a really important publication. We are drafting alternative reports on the, let's say, International Convention on all our aim is to strengthen ethnic communities so they become a part of life. We're also drafting a project of police school. In other words, all of us. That is efficient response to hate crimes and hate speech. It's a very important project to strengthen the capacity of law enforcement institutions to effectively react and recognize hate crime and hate speech to reduce the latency, increase the trust, and also promote the society to recognize such crimes. Another project that we're still continuing, Be Hate Free. We want to solve the challenges with of such crimes on the internet. We also drafted a national overview on hate crimes and hate speech situation in Lithuania. We are providing support on alternative reports platform, reports My Rights LT, the support to the victim. The foundation is taking part in the working group on hate crimes and hate speech. As regards the platform, let me tell you more. It was established by a few non-governmental organizations. It was established by the Human Rights Monitoring Institute, Human Rights Foundation, that aims to provide alternative conditions to the ones who suffered from hate crimes without reporting to the police. They can report directly. There is a problem that a lot of victims don't want or to report this to the police. Unfortunately, the law enforcement institutions do not recognize properly the phenomena of hate crimes and hate speech. So we have alternative support, efficient on the internet, and our foundation provides consultations and also helps to file complaints and draft the complaints to law enforcement institutions. We focus a lot on education. Better Together, that was a program for young people, training on international standards. International conference today is not the first one, but we're trying to make this information relevant. Back in 2018, we also had a conference on the legal regulation of national minorities. And we also focused on education, information, training on human rights issues, a right to privacy, writing of personal names. We took part in different festivals. The festival exactly. These were discussions to try to encourage a lot of opinions and discussions on the issues of human rights and discrimination. We took part in a freedom picnic. There were lots of discussions after that, and that's a great achievement, because this is our aim, to encourage discussions. the media also covers our publications, aspects that we raise. So our national broadcaster also is active. So I encourage you to follow our Facebook, our website, and I do hope that our today's discussion will encourage you to look for solutions on the issues of national minorities and other problems. Thank you very much.
So we are doing fine with time, which is very good news. And let us now begin the presentation part. And the first speaker is the representative of the National Minority Department, Ms. Vezhlita Pokladova. She will tell us about the national minority policy, its main directions and challenges. Hello, dear participants of the conference, and I congratulate you for the anniversary of today. I want to congratulate you for that, for your visibility in the national and international area. And I would like to thank you for the criticism, because it is very important for us to improve. And today I will tell you about the main activities of the National Minorities Department, about the statistical data on the situation in Lithuania. And I see that I'll be followed by other speakers who will delve deeper into this data. So my presentation will be quite concise on this. I will also present the planned strategic directions of our state in the area of national minorities in the coming 9 years. I'll try to share my screen now. I hope you can see it. So, as Ms. Barbara said, I represent the National Minorities Department under the government of Lithuania. And a couple of words now about the situation of national minorities in Lithuania and the statistics. So, the last census took place in 2011. It is happening right now as well, but based on the data of 2011, we have in Lithuania residents of 154 nationalities, which contributes to almost 16% of our public. The largest national community is Poles, then Russians, followed by Belarusians, Ukrainians, and other nationalities amount only to 0.6%. The Polish community mostly is focused in Szalczyninkai, Vilnius, Trakai, and Švenčionys regions, whereas Russian community lives in Visaginas, Klaipėda district, Zarasai, and Švenčionys. I am myself a resident of Vilnius, and this is the most multinational city. We have residents of 128 nationalities. I believe that the updated results will be even more surprised. In Klaipėda, there are 177 nationalities, in Kaunas 85 nationalities, in Šiauliai and Panevėžys more than 50. Now, in terms of the general census, I'd like to share with you the information that, as you all probably know, beginning with this census, the nature of the census has been changed, and now the census will be carried out not by going to people's houses and interviewing them directly, but the statistics department will process data it will take from the register. That is why it is not yet clear how all the representatives of national minorities will be calculated, because not all of the people have indicated their nationality in the registry documents. And there are questions whether in this way the right to indicate that the nationality has not been violated. But later, if we see any shortcomings as a state, we will be able to improve the methods of the census to have more exact data. As a department, we mostly work and cooperate with national minority NGOs. And here I have in mind specific national communities and not human rights. We have about 250 non-governmental organizations in the area of national minorities. Some of them are more active than others. Here you can see the list of NGOs and their numbers. Among the rarer nationalities, I could mention Africans, Arabians, Tajiks, Koreans, and Vietnamese. Another surprising figure is that as many countries there are in the world, and in Lithuania we have representatives of 158 countries. As the advisor of the Prime Minister said, Lithuania has to take pride in its national minorities. This is its strength and instead of a threat. So all the organizations of national minorities are represented in the Council of National Communities. It's a sort of a parliament elected from each national minority by delegating its representatives, similarly to the principle of the UN. There are 3 members of the council from the communities that have more than 100,000 people. If there are 10,000, then 2 representatives, and then 1. The Council of National Communities is the advisory body of the National Minorities Department. But it is not only us that cooperate with them, but other institutions such as the Equal Opportunities Ombudsman and other national institutions consult them and ask for their opinion while preparing relevant legal acts, because members of this council have the mandate to pass on this opinion to their communities. There are 28 members of this council and represent 19 minorities. Its functions are to represent national minority interests, take part in legislation procedures, take part in various working groups and committees, give advice on strategic issues related to national minorities, monitor the implementation of international legal acts and commitments, and propose measures for various targeted programs in the area of national minorities. Now turning to the shaping of the policy of national minorities in Lithuania and its history and the institutional framework. We were among the first Eastern European countries which raised the issue of national minorities to the institutional level. And back in '89, the first institution coordinating the issues of national minorities was established, namely the Department of Nationalities. Probably many of you remember its first leader, Halina Kobetskaite. In 1997, the department was reorganized into the Department of National Minorities and Exile, and it was entrusted with the cooperation of Lithuanians abroad. In 2010, the institution was reorganized, the functions were distributed and given over to the Ministry of Culture and Education. And the Ministry of Foreign Affairs was entrusted with the issue of Lithuanians abroad and its diaspora. The issue of national minorities is important to the government, which is proved by the fact that on the 1st of July 2015, the restored Department of National Minorities started its functions. And since then, we have been counting our years of activity. So how do we see our activities in the department? We implement the integration of national minorities by preserving their identity. And our program is based on 3 pillars. I cannot say which one of them is more important because they are much intertwined. Is it integration, the nurturing of national identity, and non-discrimination? All of them are equally important and tightly linked between themselves and also complementary. As I said, the Department of National Minorities engages in a two-way process for national minorities and about national minorities. In terms of national minorities, it is important to encourage the integration and to support the nurturing of their identity, because it is important for people to feel that they are loved and accepted and encouraged to maintain their identity. This helps them to set up and integrate in the country, to devote their efforts to the country and to trust the country. And we are also about national minorities because we don't only have to integrate them, but most often we also need to encourage the society to accept and get to know national minorities, to acknowledge their difference, and to raise awareness that in Lithuania, this tradition is age-old. This is not a new challenge. This is a long-lived experience that we could share with other countries. So the activities devoted to national minorities include partial financing of projects depending on various priorities. We have space for Roma integration, the activities of informal education, southeastern Lithuanian priority, and in our narrative on national minorities, we involve various levels of the society. We have awards to students who write their thesis about national minorities. We have awards to journalists for positive reflections of the topic. We collect information from various institutions and municipalities each year about how they focus their attention on national minorities and the projects they implement. We try to express our gratitude to those municipalities that devote more attention to this issue. Let me stress that awareness, information, non-discrimination, and dialogue are very important also in terms of our national security. This is the key interest of our state, namely that peaceful cohabitation of different national minorities complementing each other is the guarantee of our national security. So you can see on this slide the tipping points in the history that had influence on the shaping of the policy of national minorities. As I said, back in 1989, the law on national minorities was adopted. It was valid until 2010. The first institution on national minorities was established. And what helped us avoid certain disturbances in the area of national minorities? It was namely the decision on the zero nationality of Lithuania and the active rebirth of national communities. national communities were together with us on the Baltic way. They did the same as Lithuanians, and then we felt that we were one nation, and we thought that this tradition had to be strengthened and continued. In 2004, as Lithuania joined the EU, the free movement of persons began and the national diversity increased. We saw representatives of national minorities that were just one or several people in Lithuania. We saw the scale of emigration and immigration increase, and the national content changed. We lost some of Lithuanians, but we received some national minorities, which changed the national setup of Lithuania. What is the current situation, status quo? We have 154 nationalities, amounting to 16% of Lithuanian residents. We have 250 national minority NGOs. We have as many as 40 informal educational establishments, about 10 national minority culture centers with which we cooperate in the department and in the municipalities. We have bilateral international cooperation with 10 countries on the issues of national minorities, and Lithuania reports for the monitoring of the recommendations of 9 international organizations. What are the challenges that we see as a department? Namely, hybrid threats, the influence of medias. I'll talk about it later. The gap between regions, sometimes lack of civic awareness, and the impact of propaganda, and the propaganda of certain political forces, or even manipulation on important issues. Now, turning to the coming directions, national directions in the area of national minorities. I'm happy to say that in the National Progress Plan, national minorities have been singled out with a separate objective that has been transferred to the program of culture development. And the responsibility is within the Ministry of Culture. So this is a separate objective included in the program of culture and creativity development. And we're very happy to see that there is a special attention paid to this. So the objective is to promote the integration of national minorities. The program is yet to be approved, but there is already an issue raised, namely the lack of the openness of the society to national minorities, which is an obstacle for the creation of a harmonious multicultural society. There are 2 reasons for this. A lack of activity on behalf of the national minorities in the area of cultural life, and the information exclusion of national minorities. And then we can break these reasons down to other issues to be solved, namely an inactivity in cultural and social life, based on the lack of the presentation of the history of national minorities in the history of Lithuania. They are not presented as an integral part of Lithuania. In the curricula, there is still a lack of conceptual content on national minorities. Also, there is too weak coordination of the cooperation between local and national level institutions. In other words, there is a lack of institutional networking. Moreover, national minority communities and NGO representatives sometimes lack the possibilities to improve their qualifications so that they can be active in their work and to engage in project activities, both in Lithuania and internationally. National community organizations are not always able to apply for projects because of the lack of competences. Also, there should be more information about material and immaterial heritage of national minorities. And in terms of information exclusion, we see that information medias are not focused enough on the relevant issues and needs of national minorities. But the good thing is that our national broadcaster, LRT, has changed its approach. Now we feel their willingness to cooperate, to talk about national minorities. And we know that for the coming season, there are several competitions on the creation of national minority programs. We hope that we'll get producers and creators to develop these programs. Another important issue is the lack of critical thinking and information literacy, which negatively affects the approach towards national minorities. What else could I say or draw your attention to? Well, I don't know if I could say that we should start thinking or maybe acknowledge that we have been late to engage in action, not only in the area of the protection of national minorities, but also we are late to start talking about the protection of national minorities in cyberspace and the challenges that emerged during the COVID pandemic. Namely the strengthening of the cyberspace and the shift of the media to each person who has the possibility to have their own blogs, to be active on the cyberspace, to share their ideas with the society. So all of these opportunities and all of these challenges and the availability of cyberspace also poses problems that we couldn't have imagined before. And here I have in mind hate speech and violations of the rights of national minorities in public space. This is not the problem of Lithuania alone, but it is a global challenge. And the Convention for the Protection of National Minority Rights is simply not enough. We have to think about the measures how to protect these rights on cyberspace. And here I'd like to compliment the Lithuanian police who now have a virtual policeman. This is a small step forward, but an important one. We do hope that all institutions will adopt this method. And not only institutions, but also NGOs, which are frequently more flexible and quicker to notice these things. So that's it for today from me. If you have any questions, I'll be happy to answer them.
Thank you very much for your informative presentation. We will come back to some of the aspects during our discussion. And what you said at the very end, that maybe a conference is not enough to talk about cyber crimes. Well, let us move forward, and now let me ask Mrs. Dr. Monika Freitė-Rakauskienė from Lithuanian Center for Social Sciences to express her views on national minorities in contemporary Lithuanian society, social aspects and challenges. The presentation was drafted together with Professor Boguslav Gruževski, who unfortunately could not be with us, but Dr. Monika are welcome here. Good afternoon. I do hope you hear me. Thank you very much. I will share my slides. Before I start my presentation, I will try to fit in those 15 minutes. Well, indeed, I wanted to thank for the invitation to take part in the conference. I'm very happy to see so many people who think the same on the issue of national minorities. Let me welcome the congratulate the foundation with a successful 10-year anniversary. In our everyday work, I do face the work of a foundation in dealing with the issues on national minorities. I see your reports and activities. And as you've mentioned, I will present my views. Well, this is the work together with Boguslav Gruszewski. I wanted to show you what problems are faced by two biggest national minorities, the Poles and the Russians. I will speak about the challenges on their national identity and the social challenges on the labor market. Let me move on to the charts. Statistics shows that unfortunately, next to the reduction of population, the number of national minorities is reducing, and percentage-wise, the permanent residents of Russian nationality, the number is reducing. The Russians, Belarusians, and Ukrainians are dominated by elderly people. Well, because the comparative part of young people was smaller than those of elder population. The Poles, the Russians have a different structure here. Well, why is this important as a data? Then the reduction of ethnic minorities are posing challenges to the identity of national minorities, and also in the social sphere. Well, talking about ethnicity, when cooperating with Vaiva Veželytė, well, there was a report, a survey in November. Poles and Russians dominated there, and there still the language remains a very important identity of national minorities. For them, it is very important to be identified with people of the same minority, and the language is very important. The ethnic identity element is very important, as well as the social identity, to be identified with the people of the same nationality. Well, the use of national language is very important for the Russians, and Poles using their own language is very important to have the events, traditions and culture. Now, if we compare Polish and Russian groups, well, for the Poles, for the Russians, the social category is more important than for the Poles. Well, as regards the use of their national language, native language, the knowledge of Lithuanian, despite the fact that representatives of national minorities are more likely to use their native language at home, they also speak Lithuanian quite well. In the Polish group, only 3.4% of the respondents indicated that they do not speak Lithuanian. And in the Russian group, this ratio was 8.3%. During the population census, we received also quite a lot of data. And if we speak about the Russian ethnic group, wanting to preserve their national identity face more challenges than the Poles because of the ongoing assimilation processes, and quite a lot of social researchers speak about that. Well, when they speak about the Russian ethnic group, they identify this problem with the language of instruction. The number of schools is decreasing, and is decreasing faster than the number of Polish schools, as well as the standardization of Lithuanian language exam for all pupils, as well as declining importance and reputation of the Russian as a native language. Well, the research and studies I conducted with the representatives of Russian minorities, they say that the young people refuse to take part in civic organizations, and they're not so interested in preserving their own culture. If we were to speak about challenges for ethnic minorities on the labor market, I would like to say that we lack statistical data that we structure with regard to nationality. The data that singles out, distinguishes national minority. That's why it's very difficult to really single it out. That's why specific factors, specific surveys are really very important. Well, as regards the labor market, the such things as negative disposition towards them, non-possession of Lithuanian citizenship, as well as social ties and territorial mobility skills could really impact the indicators. As regards the Russian minority, they live in bigger cities where unemployment is lower than the national average. And the Poles live in rural areas mostly. And younger people face fewer problems when integrating in on the labor market. And if we were to speak about certain regions such as Šalčininkai, Širvintai, or South East Lithuania, we can see that such regions, due to the lower development rate, then the number of social benefit recipients is higher there. Well, certain municipalities were selected here, and this is why the factors and the percentage is as it is. We can see that Šalčininkai region municipality, the figures of young people are the percentage of unemployment in the group of young people is higher. Ignalina region, Kalvarijai, the figures are high. These are rural areas. And that influences the employment scope. The recipients of social benefits, the overall figure is different.
Matome, kad tas rodiklis yra aukštesnis negu bendras Lietuvos rodiklis.
Well, this figure is different. Well, what could influence on such indicators? It is important to note that the survey of national minorities, national minority groups also showed that different groups can react differently to discrimination and recognize discrimination. Only some 23% believe that discrimination on the grounds of nationality is widespread in Lithuania. But one has to focus that once it was asked additionally about Lithuanians and non-Lithuanians to get a job, to pursue their career, 31% of the respondents answered that they believe that the opportunities for non-Lithuanian citizens are smaller than those of Lithuanians. We have to actually agree that the perception and recognition and awareness of the discrimination is quite different. Not everybody sees this as discrimination. The Office of Equal Opportunities Ombudsman, in their report of 2020, announced the nature of complaints on the grounds of nationality. Another indicator that could demonstrate the discrimination, prevailing discrimination towards national minority groups, is the way that opinion, public opinion goes towards different national minorities. The Institute of Sociology and also carries out annual public opinion polls to analyze social distancing and the approach, attitude towards national minorities, whether you would like to live in the neighborhood with national minority groups, whether you would like to work together. And the third question asked is whether you would like to rent a flat to a national minority group. Well, these surveys carried out, have been carried out since 2005, and previous attitudes and attitudes now towards traditional groups such as Poles, Belarusians, Russians are not big, so the social distancing are big. These neighbors, these people and national minority groups are liked as neighbors. They are accepted by the society. We could make a conclusion. And we see on this slide the answers to the questions, which of the above mentioned groups you would not like to work with. So the social distancing is very little as regards the Poles, the Russians. The surveys show social distancing towards other national minority groups, specific national minority groups, being the Roma in this case. They were and they still are a national minority group which is accepted the least by the Lithuanians. And I will quickly conclude. I was thinking, how shall I summarize my presentation? I would like to say that social demographic processes in Lithuania are discussed really in the political and public discourse. The problems of national minority groups, and in recent years the issues of national minority integration in political discourse associated with national security, the strengthening of civic and social cohesion. Well, the public institution focused on retaining identity, gave priority to cultural aspects, not social. Well, also more attention was paid in East and Southeast Lithuania. In the public and scientific discourse of the country, the priority is given to cultural significance or aspects in terms of integration and not social integration aspects. So this was my brief presentation. Thank you very much for the attention, and I will conclude here. Thank you very much. Well, really good insights. I noted things down for our discussion. It would be really great if Dr. Monika Frejute and Vaiva Veželytė Pokladova from National Minorities Department could take part in the discussion, because I see quite a lot of topics for discussion. Now let us move on to a more international perspective. We will talk about integration of diverse societies and minority rights under the OSCE standards. OSCE High Commission on National Minorities Office, Dr. Kuzborska-Pasha will tell us about that.
Thank you, Barbara. Thank you to the organizers for the invitation. And today we can really be happy. It's been 10 years that the European Foundation of Human Rights, one of the most important NGOs in Lithuania, and the most important NGO in the area of national minority rights, is active in Lithuania. It has been expanding, cooperating with international partners. So I wish you every success in the future, and best of luck to your staff and experts. And I'm very happy that today, albeit remotely, we can still enjoy your achievements and discuss the progress in the area of the protection of national minorities, to talk about the possibilities to contribute to strengthening the human rights protection in the country. and the challenges. I'd like to thank the representative of the National Minorities Department, Vaida Veželytė, and Dr. Monika Frijutė-Rakauskienė for their presentations, where the dialogue, the security, the trust, and the openness of the society, social inclusion were mentioned as the key elements for integration. I do hope that my presentation will complement the ideas that have already been expressed. And in the beginning, I'd like to note that the Organization for the Cooperation Security and Cooperation of Europe, the High Commissioner for National Minorities, has been trying to prevent the tensions in the area of the issues of national minorities. And in the past 30 years of the activities of the Institute, the compilations of 9 thematic recommendations were published, where various insights and recommendations were presented to the member states of OSCE about how to improve integration processes, how to improve the interaction of national minorities. These documents are, first of all, related to the rights of national minorities, to the education, the protection of their language rights, efficient social life participation, and economic participation. As Monica mentioned, this is an important element of inclusion and integration, as well as the usage of various languages in the media, as well as the specific recommendations concerning law enforcement in multinational societies. This is an interesting document. And the recommendations of national minority aspects in international relations. There, the conditions are discussed whereby countries can support national minorities living in other countries. So all of these documents are directly linked with the High Commissioner's efforts to alleviate the tensions and prevent ethnical discords or possible discords. The experience of our office shows that diversity in itself is not the cause of tensions. Many conflicts that have arisen in Europe after the Cold War, ethnic conflicts, those conflicts could have been avoided. It happens so that certain national policies tend to exclude and distance certain national minorities from the state rather than embracing them as part and parcel of themselves. So all of the 9 compilations of the High Commissioner's recommendations help OSCE member states to deal with integration policy in a more efficient way. And the good news is that Ewelina Dobrowolska, the Minister of Justice, together with the Department of National Minorities and its director, Vida Montvedaitė, have spared no efforts to make these recommendations available. They have been translated into Lithuanian. It's almost 1,000 pages, and this is an invaluable source for politicians and civil servants engaging in national minority policy in Lithuania, as well as scientists who would like to learn about the standards. I encourage all of you to read these documents. They are available at the website of the Department of National Minorities. So today I'd like to briefly review the key principles of efficient integration from the OSCE perspective. As the representative of the National Minority Department said, integration is a two-way process involving the minority and the majority. The majority, first of all, has to acknowledge and to get to know national minorities. The acknowledgement and the knowledge of national minorities is an inseparable part of the identity of Lithuania. And moreover, diversity is a feature of all modern societies. And in order to efficiently manage this diversity, all communities have to be involved in order to shape integration policy together. Today, I'm going to speak about the Ljubljana recommendations of OSCE concerning multifaceted society integration. This document defines guidelines based on which each country forms its national legislation. In this case, the case of Lithuania, it is first of all the law on national minorities, or its draft. A couple of words now about non-discrimination and the equality principle. This principle is sometimes mixed with the identity approach, which is erroneous. A harmonious approach does not mean identical approach. And in order to ensure the efficiency of the principle of equality, in some cases, it is necessary to have a different approach to certain persons so that they can use all of their rights equally with other members of the society. So, if need be, and when proper, special measures have to be applied in order to ensure a full and efficient equality of disadvantaged groups and to achieve real equality, which means that people can achieve the same results in certain areas of politics, social life, and economic life. Let me stress that these measures are not discriminatory if they are based on a legitimate objective and are proportionate to the objective. Another observation is that national minority rights are part and parcel of international human rights norms, and they are not any special rights, and they are in no way discriminatory in respect of the majority. Sometimes we hear, especially from politicians, that we cannot allow the usage of minority languages in public space because this is contrary to the imperative of the protection of the national language. And let me stress that minority languages in the public space could be used along with and not instead of the national language. So, in other words, certain rights of minorities do not deprive the majority of anything. They simply complement the package of the norms of human rights that have to be ensured in the state. In order to promote the integration of the society, and please note, I'm not talking about a national minority integration, but social integration, states should acknowledge the diversity of their population and instead of trying to assimilate them, quite the opposite, they should provide them with all the possibilities to nurture their culture and to participate in educational processes. The participation of national minorities in the social and economic life of the country is equally important as their participation in state affairs. In my presentation, I'd like to develop this topic a bit more because their participation in social and economic life is a very broad notion and includes a lot of issues, including proper housing, healthcare, social protection, education, and employment, including the participation on the labor market and in both public and private sectors. More specifically, what the interpreters are sorry, but the view and the speaker is frozen at the moment. There is a technical glitch. Okay, so the inclusion on the labor market of national minorities is very important. This policy has to be based on evidence, on the assessment of economic needs and interests. The strategy and the policy has to be shaped and implemented and monitored regularly and while consulting with all the stakeholders. If needed, specific measures have to be used, including curricula or the usage of their language in the workplace, where appropriate. The country could apply specialized training in order to better prepare the staff of public services and welfare institutions to react adequately to the needs of national minorities, including language needs. State enterprises could also engage in inclusive employment policy. Countries could also encourage private sector employers to contribute to the integration process. And this could be achieved by the cooperation between the public and private sector, or by facilitating the employment of national minority representatives. Another recommendation is to include local communities, especially living in more disadvantaged areas. Targeted economic recovery and regional and local development projects should be developed and implemented. It is also useful to think about the cooperation between border regions, between neighboring countries and their regions. This is another efficient way to achieve certain economic indicators in the border areas. In general, states have to think about and take into account the requirements in the legal acts and how these requirements influence the possibilities of national minority representatives to participate on the labor market, for example. Maybe some of these requirements are superfluous in certain areas. The countries should approve specific and targeted policy in order to make sure that all have adequate possibilities to efficiently participate in democratic processes and decisions. So countries have to aim at achieving that in all public administration structures and institutions, different social groups, including national minorities, should be represented properly. In other words, the government has to want to hear the voices of national minorities and their opinions. Now, a couple of brief comments about languages, the state language and the languages of national minorities. In the state policy, there has to be a balance, as has been mentioned, between the need to have one official language as a common language, a common basis for the integration and functioning of the society, and the need to protect and promote language diversity. The balance between these two aspects is very contextual, and it is different from country to country depending on the situation of each national minority. Our experience shows that the arguments about this balance are frequent and could give rise to certain tensions. When a multi-language country has one state language as an integration tool, the permission to use other languages in the area of media, education, could help satisfy the needs of national minorities and promote their inclusion. So the nature and level of language usage in public administration should be established based on the specific circumstances of communities and their needs. And the last element of integration policy I'd like to briefly discuss is education. Otherwise put, the education policy should be shaped as part of integration. States should respect the right of national minority representatives to be educated in their mother tongue based on the need, especially in traditionally inhabited areas. I recently read one foreign article about Lithuania. How is it good to be a Pole in Lithuania? From kindergarten to university, you can study in your mother tongue. And this is true. This is a good example of Lithuania, and this example should be preserved by not deteriorating the situation in Lithuania. And here again, we speak about the balance in education policy documents, where we should strive for the balance between the right of national minority representatives to be educated in their mother tongue and the need to create a common educational space with equal possibilities for all to receive quality education. While looking for this balance, education policy should be, among others, based on efficient participation principle. In other words, in order to ensure the participation of all stakeholders in the education area, all students, parents, and communities should be encouraged to be involved. It is not acceptable when the changes in the education of national minorities are simply published or implemented without any efficient involvement of national minorities. So, to sum up, integration is not a unilateral movement, a one-way movement. The elements of efficient integration include the participation of the national economic, social, and cultural life. In order to ensure the efficient participation of all members of the society, we need targeted documents, policy documents, and strategies that could support and encourage, also through special measures, the participation of national minorities in the areas of public life that I just mentioned. Thank you for your attention. Thank you for the invitation. And I do hope that I'll be able to answer your questions and participate in the discussion. Thank you very much. Thank you very much for your presentation. This was Dr. Elżbieta Kuzborska-Pacha. And I'm also very happy that we have our own representative in such an important institution, which can objectively take into account and have a deep assessment of the situation of Lithuania. I know this from my own experience, from my own life, and this can be very specifically compared with OSCE standards. Now we'll listen to the presentation of Birutė Sabatauskaitė, who is the Equal Opportunities Ombudsman of Lithuania. In previous presentations, there were ideas raised, for example, by Ms. Vaiva, that indeed hate speech is gaining momentum, especially on the internet. So it will be very interesting to hear about these cases and about how could we maybe not fight, but how we could prevent them.
Good afternoon. Well, happy birthday. I'm very happy. I'm very happy to be here. Well, there are certain technical glitches.
Bet norėjau pasakyti, kad be galo džiugu, kad tokia organizacija veikia Lietuvoje, kad aktyviai teikia pastabas.
I'm very happy that such organization is very active in providing feedback, representing people in the courts. It is one of organizations that helps people experiencing discrimination. And that is great because in quite a lot of cases of discrimination, people don't feel safe on their own to file a complaint. They don't have the knowledge. I do know that we are very pressed with time. I will try to be as fast as possible. I will share my slides.
Taip, tai mano šiandienos pranešimas yra apie lygias arba galbūt nebūtinai tautinėms bendruomenėms ir norisi
my presentation is about equal or unequal opportunities to national minorities and what should one done in experiencing discrimination. I will not repeat what other speakers have said, and just to note that our approach in the society attitude really focuses, really contributes to discrimination. Well, maybe people who are not speaking could mute their mics so we don't have any disturbances. So public attitudes correlates with their behavior in our everyday life, which is work, education, and once we are grown up, professional development and people for having kids, taking them to school influences their behavior and the overall mood of people. Back in 2019, Eurobarometer carried out a survey how people recognize and perceive discrimination. People were asked to answer whether this area or type of discrimination is widespread. In Lithuania, 18% of their residents say that ethnic discrimination or discrimination on the grounds of ethnicity is widespread, whereas the situation in the EU is bigger. So maybe the situation is not really well reflected, or maybe the recognition, the perception of discrimination is not well recognized. Here we see bigger percentage with regard to the Roma community, as Dr. Rakauskienė also said that this is determined by the bigger social distancing. Well, I only put one opinion poll from only parts of the survey when it was asked who with you would not like to live in your neighborhood, and the Roma are the community that is most disliked. Other groups don't have such a representation. Well, that does not necessarily mean that this reflects the situation, but this is one of the indicators that could show the situation. The attitudes towards certain ethnic minorities could be determined by political situation, by certain discussions. Last year, when the media survey was carried out before the elections, the negative attitudes towards certain ethnic groups were more pertinent, especially to the group of the Polish minority. This could determine the bigger social distancing. Let me focus on the ban on discrimination in Lithuania. Well, the equal opportunities principle is enshrined into the Lithuanian constitution.
Pat moterų ir vyrų lygių galimybių įstatymuose ten yra ir numatyta lygių galimybių kontrolieriaus tarnybos kompetencija arba mano kaip lygių galimybių kontrolierės kompetencija, kur vadovaujasi. Tai čia norėtųsi pastebėti, kad jūsų...
Sorry, the sound was gone. Well, Barbara also spoke about hate crimes, and this is one of the areas where we carry out prevention, but hate crimes and hate speech is not within our competence when we deal with our complaints. So we need to emphasize that hate speech and hate crimes is the area, the remit of the criminal law. And the report should be filed within the police. If you want to learn more about hate crimes, we have a website, nepika.lt. There you can find more information, who to address, where to address for help. And this is very important as well. Why discrimination is banned? There are 14 grounds, and very often when the complaints on discrimination are filed in multifaceted, multi-discrimination complaints on the grounds of language, ethnic minority, ethnic origin, are filed together. Well, the municipalities and also public institutions are banned from to discriminate people, and also on the area of labor law, services and goods, organizations. Well, why people file complaints on discrimination? Here you see the percentage of complaints percentage-wise on regards of with regard to different grounds. This is race, nationality, language, ethnic origin, and citizenship. 85 back in 2020. This does not mean that this reflects the overall situation. Well, the discrimination banned in the law on equal treatment is harassment, sexual harassment, also this is indirect discrimination. Talking about labor area, one of the areas of discrimination forms which is banned is direct discrimination. This is behavior with a person when for him or for her less favorable conditions are applied to that person than to another person applied in similar circumstances. This is a theoretic basically situation, but in specific situation, for example, we received a complaint when the complainant was told that they have an improper accent, even though the complainant said that she was working in Infoline and communicated with people every day, had no problems as regards communication. So in this case, it was recognized as direct discrimination in labor area. Well, what is this labor area? Very briefly, I will mention a few things. The employers have to comply with equal treatment when recruiting a person, be it a private or public sector. Professional development opportunities have to be the same in acquiring work experience. And once the assessment of employees is being carried out, the equal treatment principle should be applied. So, as well as dismissal criteria from work should be the same. Well, when reorganization the company is carried out during this process, if more people from a certain age group or nationality are being fired, dismissed, this could be one of the indicators that could demonstrate discrimination on the labor market. The employer has to pay equally, remunerate equally for equal work, ensure the protection from sexual harassment, and create equal opportunities to get work, to aim for career, and for the disabled as well. Well, the example of harassment. In public discussions, very often harassment is considered to be only sexual harassment. But I would like to focus and tell you that harassment could be on the grounds of language, ethnicity, nationality, age, sexual orientation, and disability. What is harassment? This is unwanted behavior with the aim to insult personal dignity, with the aim to create, or when hostile environment is created. I'm emphasizing create or aimed to create because the law does not distinguish how this is done, but this could be any behavior, insults on the language. Sometimes you can say, I did not want to insult, but if this behavior is considered demeaning, then it is considered to be harassment. For example, these are the examples of harassment in the labor market. In the area of services and language and goods, harassment is not banned. The draft law is on the parliament, and we do hope that for people who receive services and goods, their harassment will be banned. This is a quotation from the Constitutional Court that ruled out on harassment, more sexual harassment, but harassment overall, that the behavior is considered to be harassment, and it is important how the person who was being harassed perceives that. So if these actions objectively really cause trouble to the person being harassed. Consumer rights area. One of the complaints filed when the entertainment company Vaiduokliai internet website was information was provided on the trip, on the guided tour, extreme trip in the Roma settlement or Roma Tabor in Lithuanian has a negative connotation that all people will have a guided tour in the Roma settlement, and the people are not recommended to dress up very much, to wear jewelry because they can be stolen, and there were lots of discussions that this is harassment. Well, there are not we don't receive lots of complaints, but we provide lots of consultations and requests on the challenges to find the housing for the Roma representatives. Roma representatives come to look at the rented flat, and then the people who rent the flat see that Roma representatives come. They say that the room or the house is no longer to be rented. People sometimes don't expect people to file a complaint. We encourage people to address and to file a complaint in such cases as well. Well, issues pertaining to the area of education. There are lots of question marks and lots of discussions being raised on the political level, whether legal regulation and secondary legal acts ensure equal opportunities, equal status, equal start to all national minorities. And with regard to a figure allocated for local national minorities, were being discussed in the Education Council, whether education curricula content is sufficient and integrating, inclusive to all communities. More focus should be put on different national minorities in education curricula and everyday curricula, whether the state national exam, Matura exam assessment ensures equal treatment to individuals, whether equal opportunities for pupils are ensured, those who aim for university education, higher education. Well, the Matura exam of the Lithuanian language is required for all, but the situation is that for national minorities and in other schools where the language of instruction is not Lithuanian, the number of hours of Lithuanian language is different. This could be considered maybe not equal treatment, because then people don't get equal opportunities to get a job. But when we take part in the working group, we do hope that there will be amendments on the law. Very briefly, what is not discrimination? It does not cover all areas, but if there is a requirement to know state language by the law, this is not discrimination. Such a requirement is not discrimination. The requirement to know the national language does not mean that you can be humiliated because of your accent, or you speak with an accent. You cannot be insulted because of that. This area is being discussed publicly a lot. Also, when due to specific professional activities, a certain characteristic is essential of a human being, a professional requirement. For example, if there is organization provides aid or legal assistance to certain national minorities, for example, Russian, then it is natural that there is a requirement to know Russian language, to speak Russian in Russian. So to be able to provide such services, also special measures, health care, safety, security, employment provided by the laws that aim to create integration or integrate into the labor market the employees. So to focus that positive discrimination is not considered discrimination. So yes, in scientific literature, positive discrimination is being encouraged because not all opportunities are considered, not equal opportunities are created to all groups. Then it is not considered discrimination. All other cases will be considered discrimination. This is why we're encouraging more, if there is a need for national minorities, to ensure equal opportunities, and these equal opportunities are not created due to attitudes, conditions. they must be ensured and provided by the laws. I will skip certain slides, but it is very important when people file the complaints on discrimination, they should have more information. This could be records, sound, pictures, photos, some material evidence, pecuniary evidence, because the burden of proof is shifted then on the person who has supposedly violated the law. But in order to start the investigation on discrimination, there should be certain circumstances that should be indicated. If they are not present, then we cannot deal with a complaint. What about the challenges on discrimination? Well, it is obvious that people are afraid. We notice from our consultations that in smaller towns there are few employers and people are afraid to really report on discrimination. There is protection foreseen, but people very often see that even if you are anonymous and you live in a small town, one can see very quickly who filed a complaint. So we need stricter legal protection. In certain cases, people don't trust the institutions and equal opportunities ombudsman, or don't believe something will change.
Trūkumas ypatingai tais atvejais, kai yra, pavyzdžiui, darbinimas ir pokalbis dviejų asmenų, dažnai sunku įrodyti, dėl to mes raginame asmenis geriau tada pasitengti arba įrašyti kažkokį tai pokalbį, kad turėtų asmenis įrodymus, jeigu įtaria, kad gali būti daromas pažeidimas jų atžvilgiu. Na ir tuo pačiu norisi pabrėžti, kad diskriminacija ir lygiateisiškumas negali būti užtikrinamas tik per skundų teikimą, dėl to lygių galimybių integravimas darbo vietos ir diskriminacijos prevencija nuolatinė švietimo sistemoje yra be galo svarbi. Ir matau, kad laikas bėga į pabaigą, tai noriu pastebėti, kad ir mūsų kontrolierių, mūsų tarnyba su ekspertais visais tikrai veikia daug ir diskriminacijos prevencijos ir švietimo srityje. Ir norisi paraginti asmenis ir darbo vietoje norinčius užtikrinti lygias galimybės asmenims apsilankyti lygybėsplanai.lt. Na ir taip pat mes tikrai stengiamės teikti ir pasiūlymus teisės
aktams. We are trying to provide proposals to to the legislators to also provide equal opportunities. This is where people could consult us by email, or also send us a letter, or well, you can also see us tete-a-tete, but now we do not recommend you to the pandemics, but you can also submit a complaint here, lygybė.lt, LT skundas, and there you'll find information, what information we need to provide.
And to finish, I'd like to observe that more attention is paid to the tensions in the society, especially evident as of late, and the rising tension in other social networks. We would like to see qualified assistance and support ensured to people who have been exposed to hate. At the moment, it is mostly non-governmental organizations that provide such assistance. So it would be nice to see that the government, while shaping their priorities, ensures this support to people who have been victims of hate. And also more focus should be paid to the areas already mentioned, for example, the law on national minorities and the writing of personal names. Thank you for the opportunity to take part in this event, and I am eager to hear the next presentation about the spelling of personal names. Thank you very much for the extensive and informative and important presentation, because the information about the cases of discrimination sometimes is not enough, and people who are exposed to such situations are not even aware that they have been exposed to them, and they don't know that they can do something about it. They simply accept it, and they believe that nobody is going to listen to them. However, it can be that steps are possible, measures are possible to prevent similar cases. But when these cases do happen, it is very important at least to react to them properly. So thank you very much for your presentation. As you said, the next presentation is about the spelling of personal names in Lithuania and the developments in this area. It is still a topical issue, and it is difficult. It's still difficult to solve it. Some even would say that it is still unsolved. So the Dr. Lukas Varden is now kindly asked and invited to tell us about the developments and evolution of spelling of non-Lithuanian names in Lithuania.
Hello, good afternoon. Can you hear me well? Can you hear me?
Yes, we can hear you.
Okay, that's good. Okay, my name is Lukas Varden. I'm here on behalf of the European Human Rights Foundation, where I'm expert since quite a long time. Just one disclaimer, because I also work for the European Commission, so all the statements which I'm going to give here have nothing in common with the position of the European Commission. It is a very interesting topic, evolution of the legal matters concerning the spelling of non-Lithuanian names and surnames, because it's something which I've been witnessing in practice for more than already 14 years, and I wanted to share with you some insight of it, because I think it's a very interesting positive story in some sense, which shows how you can, via the legal system, change the mind settings, like it was in the USA with the Black movement in the 60s, 70s, where the court cases have changed the racial segregation. So I think it's a hard example, but it shows the problems which citizens of Lithuania, non-citizens of Lithuania have been facing, are still unfortunately facing, as concerns the spelling of the names. So what is the issue at stake? So first of all, we have every sixth family and children of Lithuania are born in a mixed marriage, and there are also every 6 marriages in Lithuania or abroad conducted with a foreign element. And then on the other side, we have every 6 citizens who belongs to a national minority. And this obviously brings some positives as concerns the culture and diversity, which has been already subject of the previous prelegents. And here you have examples of the names which are being Lithuanized or have been Lithuanized in the past, which actually means that the names like Krzysztof, the Polish one named Krzysztof, is misspelled and introduced in the Lithuanian language, despite the fact that there is already a name, equivalent name in Lithuanian. So there is a creation, or artificial creation of a name which does not exist in the Lithuanian language, and thus it's actually jeopardizing, in the end of the day, the language itself, because it implements something or creates something which doesn't exist in none of the languages, especially not in the Lithuanian one. So what are the facts? So first of all, it is the fact that officially there are no characters, some characters, alphabetical characters in the Lithuanian alphabet do not exist, like W, X, Q, and also specific characters from the other Lithuanian, from the Latin alphabet. There are over 300 of them, specific diacritics. We know also there are already few thousands of Lithuanian citizens, not only Lithuanian citizens, who do possess names with non-Lithuanian characters, and which those names are already inscribed in the national register, and those have already the name spelled correctly in the documents. And something which is the most bizarre since the beginning is that despite the fact that there are no characters, those characters mentioned in the Lithuanian alphabet, there is a common and widespread use in the language sphere in Lithuania. Just to mention the car plates registration, you can have QWX, you can have all the trademarks, company names, tourist information signs, even the keyboards you are using if you look at in front of you. So from that perspective, it's quite interesting. So what is the most interesting is when you go back to the year 1938, so before the war, in a very fragile period of time when the minorities have not been really much protected in that period, we see a provision in the law on family names, which does clearly state that everybody might ask to have their name and surname written in their own language, in the alphabet of if the alphabet's the Latin. So it's already, when we go back, the opportunity was already there before the Second World War. So I think it's important, especially for our guests from outside Lithuania, to just sum up shortly about the current legal provisions. So we have on the one hand side the Constitution of the Republic of Lithuania, which stipulates that the official language is Lithuanian, as probably in most of the countries in the world, even though there are some who do not have it. And then we have the Supreme Council of the Republic of Lithuania, which adopts the resolution concerning name and surname spelling in the passports, and which states that names and surnames have to be written in the Lithuanian alphabet. Then we have also the Civil Code, which also confirms that the names, surnames, places are to be written in accordance with the rules of Lithuanian language. I think it's more far-reaching than only stating that you have to write the name in the alphabet, because this allows also the so-called Lithuanization of the names. And then you have the Article 15 of the law on the state language of the Republic of Lithuania, a law which is quite important, has a very important status in the Lithuanian legal system, which confirms that person names are changed and adjusted in accordance with the legal procedure of the Lithuanian state. Let's concentrate now on the very interesting path, starting already just mentioned in 1938, and then the changes with the 91 resolutions, and then the status of the Lithuanian language. And we have then the first judgment of the Constitutional Court on the spelling of names, which states in 1999, it is important to remember that this time span, that all citizens, the surnames of all citizens have to be written documents in the Lithuanian alphabet, and this does not contradict the Constitution. The Lithuanian language has a constitutional value, which is clear because it's inscribed in the Constitution. And it's very important to now, going back to that period, to listen to the argumentation, which sometimes might seem very interesting. So the Constitutional Court stated that by writing those names in Lithuanian version, it preserves the identity, integrates a civil nation, ensures expression of national sovereignty, it integrates indivisibly of the country and normal functioning of the state and municipality institutions. And then it goes further on that it's an important guarantee of equal rights of citizens. So it's here we have the reversed equality. So the minority has to assure the equality of rights of the majority. It's not the vice versa. And it allows for all citizens to communicate with the state and local municipal institutions on the equal conditions, implement their legitimate rights and interests. So again, here the minority has to comply with the majority of the state. It's stated clearly that has to be a law which establishes ways how the language used in public life is provided and how the language should be protected. It also goes further. It pushes further for the use of language in the public life, that there is no way to use other language than Lithuanian. It's a compulsory in all areas of public life. The issue of the documentation, the passport in this regard, because on that time it was still the passport, one of the most important ID document, is that in those documents it should be written in the state language, the name and the family name. And very, very interesting to additional argumentation, then a contrary interpretation would deny the status of the language as the state language and as a constitutional value. So here we see that the possibility of using surname names differently than the Lithuanian language would undermine the status quo of the state, which is quite far-reaching. And it would not only deny the constitutional principle of the state language, but also violate activity of the state and local municipality authorities and other enterprises, institutions and organizations. So actually what we can read here, by allowing using the surnames and names in the original form, it would actually mean a collapse of the state language. So it's a quite far-reaching interpretation of the name of the language rights. We have 10 years. 10 years after, we have another constitutional judgment, which is not as excessive as the previous one. It says that if the person's name and surname is written in a non-Lithuanian characters and non-grammatical form in other recognized sections of the passport, it can be allowed, meaning that it would be possible to have the name, surname written on another page of the document, but it will not be treated as an entry equal to the record. So it will be not an official name. It would be a nickname. It would be something which not really is not clear what the constitution meant, because it's you can always have some inscriptions in the document. So the Constitutional Court is already opening its interpretation on concerning names, looking from 10 years before, and it already allows some maneuver and freedom in this respect, because it allows to have some sort of original version of the name put in the official document, even though it would not be officialized. It would be something which is not really legalistic. And then it goes that it should be obviously legislature which should provide the legal basis for it. I think this is something which is very important to remember, because it's not the first time that the courts will say the legislator has omitted to do its job to provide legal basis for the name spelling. And then we have 5 years after, so we have 1999, 2009, and then we have the judgment of 2014. And here we see a wider opening of the Constitutional Court judgment, because it states that it's also possible to establish the rules of writing the names and family names in the passport other than those established by the resolution of the Supreme Council. I mentioned 1991, so it's actually saying that you could envisage other ways of interpreting what was stated in the resolution, and it goes around the 1999 court case. So, and they were important because in this judgment issued 7 years ago, it states clearly that the names could be spelled using not only those letters that are contained within the alphabet of the Lithuanian language, but also using symbols of Latin origin, which is quite a big step, allowing to use diacritics. So all the possible diacritics in the Latin alphabet. And here, in order to do it, there is a need to consult a proper institution, which has the authority to do so with all the Lithuanian language specialists. So we are seeing a widening of the approach towards name spelling in the span of 15 years, which is quite interesting. There is also the State Commission of Lithuanian Language, which has been changing its attitude as well, and I think it's very important to mention it, because this is something which is this commission is the main important institution to protect the Lithuanian language. And here we see an evolution of the position, in which the commission states that names and surnames of citizens of the Republic of Lithuania in individual documents should be written Lithuanian alphabet, but given the current needs of the society, with some possible exceptions for surnames. In here, it would be for the citizens entering into marriage with foreigners, and also for the children. So it is a step which was quite important, because the State Commission plays a crucial role in the whole span of judiciary on the local level, against the non-inscription of the names and surnames. The same for the foreign surnames, and this is, I think, very important when we look at the previous 1999 court case, that here the State Commission still claims that foreign surnames do not form a part of the Lithuanian language. And I think it's very important statement, following that it is not necessary to Lithuanize them in Lithuanian text. So it actually confirming what or going against what was in the 1999 court case, because it states clearly that the names which are not Lithuanian names are not part of the Lithuanian language. Actually, they make it not Lithuanian, and they should not be recognized as such. So this is the reason that why they should be looked from apart, from around the system, and the rules of the Lithuanian language should not apply to them. And this is something a very crucial change in this regard, which makes the evolution of the court judgments also easier. And here I wanted to concentrate on two issues, on two cases. I mean, actually, two very important to mention. I'm not going to go into detail because it's quite already old, but I think it deserves a mention. Michał Kleckowski, who was the first one who went against the apparatus, the legal apparatus of the Lithuanian protection of the Lithuanization of the names, who dared to go against the country and went to the European Court of Human Rights. I mean, his uncle, and then he took over. Unfortunately, the court declared this case as inadmissible. It is because of rather procedural elements. And the same then for the Human Rights Committee in 2007, where also procedural aspects played quite a crucial role here. But I think it's important to show that there were cases of fights, and I think this is also the situation where we jumped in, because the Human Rights Committee issued its opinion in 2007, and this is where the case of Małgorzata Runewicz-Warden, and Łukasz Warden came into play in 2007, followed also by the European Court of Judgment exactly 10 years ago on the 12th of May. So we are having an anniversary of 10 years. So it's not only the establishment of the European Human Rights Foundation here, but also of the court judgments. And the court judgment, which for some at the beginning could have been seen as not as positive, but in the end of the day played a crucial role in the overall jurisprudence of the post 2011 name spelling in Lithuania. I will concentrate here on this ones because we have only few minutes to present. So I wanted to show the evolution, because on this case we see a clear evolution of the court judgment. Before I go into it, I just wanted to clarify some legal aspects for those who are not familiar with the Lithuanian system. So if you have a childbirth or marriage certificate, you ask for a certificate in the office, and then it's denied. You go into the court, and in the beginning you would lose the court and you would go further. Now you, in 100% cases, the courts are in positive, and then you go to the statistical office to get it recorded in the registry, and then the migration office is opposing it, still opposing the inscription of the documents, and then you have no other choice than to go to court, and then to court of appeal if you don't win this, and then you go to the final judgment. Normally the courts are also positive, but the migration office is appealing always those court cases. So we are talking here about quite a few years of legal battles with all the stress and legal uncertainty. And this is, I think, very important to underline. Why? Because in the end of the day, there is still no solution, grassroots solution for all the cases, and it's still the court cases which have to be taken on board. And I think this is still a set conclusion of since it takes already so long time that there is no overreaching conclusion for everybody. So we have, after the court judgments, seen 391 from the European Court of Judgment, Luxembourg. We have the District Court of Vilnius taking its judgment. So the preliminary ruling, I'm not going to get into it because it's here less important. The court has the preliminary ruling back on its in its court, and then it has to judge based on the preliminary ruling. And what it does say is that different spelling of name and surnames in various documents might be the origin of certain inconveniences, but the inconvenience is the fault of the party, who, in spite of holding the identification document with the name and the surname written in Lithuanian font, amended the birth certificate in Poland and gave the name and the surname in Polish. So the court is saying the problems you're having, it's your problem, you caused them, and you have to live with them. So it's very interesting to have this way of interpretation. So it goes further, saying that it shall be assumed that in this case the national provisions do not induce any considerable administrative, occupational, and personal inconveniences. And it goes further, even if there are any inconveniences, they're only personal and existential, so they're not really important and they should not be taken into consideration. Thus, the motion was rejected. Obviously, there was an appeal. And the appeal, which judged 2 years after, stated only that the inconveniences which is experienced by the applicants cannot be considered as serious. So, in order to avoid any inconveniences, if there are any, it is enough to present additional documents translated into relevant language. So if you go to States, you do it in English. If you go to India, you take it into India. You have to translate all the languages you need before you go to travel, but it's a small inconvenience. And very interesting, I'm underlining this as well because it's something which later changes very much, is that the appeal court stated that the registry at the Ministry of Interior, which has provided a list of few thousand names inscribed with already combination of foreign letters, or like Małgorzata, because Małgorzata was already in this registry, is not informative. It's an abstract information. The grounds for using these combinations were not revealed. So this does not give the grounds for substantiating concrete conclusions. Very interesting conclusion from the appeal court. And then we have a huge change 3 years after, where we have the court case for the child, which is perhaps easier because of the clearly jurisprudence of the European Court of Justice on the name spelling, Garcia Velo, for example. So here the courts, the same Vilnius City District Court, states that different spelling already causes inconveniences and might cause even greater problems in the future. So we see a change in the mindset of the court. It also points out to the problems on the free movement within the EU. Here, we have the different approach at the registry, because here the court says, here it's important to see that in the Ministry of Interior you have persons registered with their names and surnames spelled with the letter W. So here, in contrary to what happened 3 years before, the court says, yeah, it's important. There are already names written with W, so we should not discriminate the applicant here. And very important for the minorities protection, for the first time you have a reference in the court judgment to the Framework Convention for the Protection of National Minorities, especially Articles 7 and 11, because the child belongs also to a national minority. So we see a huge shift in this regard, only in the span of 3 years after the last very negative judgment. And following this, it goes further. It says clearly that the names do not pose a threat to the protection of the Lithuanian language. So it's quite a huge shift in this regard. And the statement of the Commission of the Lithuanian Language, which I've already quoted, about the demand of the society and some expectations in this regard. Then we have, as you can see, few months later, we have another court judgment. This goes to Mrs. Małgorzata Runiewicz-Warden, which here, after the long battles, there is a change of the family name, Varden to Warden with W. And here the court considers the European Court of Human Rights judgments relevant, again pointing at the registry, that there are already W's inscribed into the registry. Then it concludes that the spelling of applicant's signature is significant, and the very spelling of the surname can cause inconveniences to the applications which may increase in the future. So here we have even more taking on this argumentation brought by the applicant. And something which I've already draw your attention to, the lack of the legislature initiative, which was also requested by the Court of Justice of the Constitutional Court of Lithuania, asking the legislator to take actions. And here the court states clearly that as there are no actions of the legislator, they have to be taken measures in order to allow the spelling of names, in order to avoid problems, serious problems of the diverse spelling within the EU. So something which shifts much more. And then we have 3 years after, so the next judgment 3 years after, we have the spelling of the first name, the Vilnius District Court 2 years ago. And here also interesting, because we have the first time reliance on the United Nations Human Rights Committee, based on Reichman and Latvia case, and the Article 17 of the International Covenant on Civil and Political Rights, that forceful name change is an unlawful interference with the privacy of the person and violation of human rights. So the district court goes even beyond the national law, constitutional law, EU law, and goes and the convention, Minority Rights Convention, and it goes to the United Nations Human Rights Committee. So it's quite important further opening of the internationalization of the judgments in Lithuania. And here, very interesting also that the court stated that even one letter changed against the will of the individual should be considered as a change of the personal name, and should be subject of the
Tai jau turi būti laikoma asmenvardžio pakeitimu.
Coming to an end, it is quite interesting to see the evolution of the name spelling in Lithuania, which started with the court judgments in Vilnius, but then slowly spread around different
Teismų
cities.
sprendimų.
And here you have examples of the names and family names which changed in the framework of those years in Lithuania. You can see the differences in spelling. Some of them are quite quite big. And there are already situations where there are changes without the courts in the registry, for example, for the names, like here from the rationalized Russified name of Michał to Mikhail. So it is already an improvement in that sense that the person in question doesn't need to go through the court cases. Only this year there have been 15 cases won as concerns name spelling, and there are still 25 cases ongoing in the European Foundation of Human Rights. So it's something which is still ongoing battle, and it would be good that finally the legislator would take into consideration all the cases and the various changes as concerns interpretation of the national but also international jurisprudence, and legalize and also uniform the possibility of having names and surnames spelled in the original version in the Lithuanian system, in order to avoid the long-lasting cases and the problems which are deriving from it, because each case takes quite a long time. I mean, we are still in the fight for the Runevik, because you see the Małgorzata Runevik Warden is it's in the Warden we have the W, but in the first name family name it's still with V. So we have still, after 14 years of ongoing processes over almost 10 different court cases, there is still battle to go ahead. And despite the fact, I think it can be clearly stated that there has been a shift in the Lithuanian jurisprudence, which is very positive, and hopefully it will last and push the legislator to change the legal basis and to ease the life of both the mixed marriages and couples and their children, as well as for the national minorities. Thank you very much for your attention.
Dėkojame daktarui Lukašui Vartinui iš tikrųjų už.
Thank you very much, Dr. Lukasz Vartan, for your presentation, for the development of writing of personal names and persons who haven't really imagined the scope of the problem. I think now can see the situation better. We don't have that much time for the discussion. We have some time only. It would be very interesting for us to discuss certain aspects. If you have certain questions, please write on our chat. Put them there. I will start the topic myself, which became really interesting to me from the past first presentations. As Dr. said, Dr. Monika Frejute-Rakauskienė mentioned from 2005, this social distance is reducing, and the data shows, the research shows that basically we don't have negative attitudes towards national minorities in the public. But as Mrs. Vaiva from National Minorities Department noticed, and what the data of Equal Opportunities Ombudsman also says, what is becoming more active, we have cases of discrimination and also hate speech towards national minorities, especially on the internet. What do you think? What influences that, and how could one change that? Any of the speakers would like to say something on that topic? If I may, as regards the attitudes of the society, yes, as of 2005, I cannot really say that there is a drastic reduction, especially speaking of those groups, not to speak about Roma people. We see a trend that there is, the trend is fluctuating, and it depends on certain data. I was really interested in that previously, and the attitudes correlate with what is described in the data, in the media, for example. Okay, the situation in recent years. For example, the Chinese. Back in 2020, there were lots of negative attitudes towards the Chinese. And we see the situation and that China was blamed a lot, geopolitical situation with regard to Russian aggression in Ukraine. And people start also identifying that with national minorities, or as, for example, it was mentioned, I don't remember what, with a Polish minority. We see how the Poles are being described in the media. And this is identified with political parties and their activities. People don't see that as a separate, as politics, but see that group as a part of their leader. And this is how attitudes shift and change. We need to draw their attention that some people say, I don't want to live with them or to be near. We don't have such a distance with Poles and Lithuanians as we do with Roma population. We have one more question. Let us shift our discussion. Dr. Liucija Georgovich is asking to Mr. Vežilė Pokladova, could you expressively explain the current developments with the draft law on national minorities? In which stage is the process now, and when do you expect the law to be adopted? Also, were representatives of national minorities involved in the drafting process? Also, another question, whether national minority representatives were present during the drafting of that law.
Taip, stengsiuos trumpai. Ačiū už klausimą.
Thank you very much for your question. The law
Projektas buvo rengiamas 2020 metais. Kultūros ministerijos pavedimu buvo suburta darbo grupė, į kurią įtraukėme.
The working group was basically compiled and that took part in the drafting of that law on national minorities. There was an open call. Everybody could take part there.
Darbo grupės narių turėjom ar 6-7 atstovus iš bendruomenių, taip pat iš
So we had 25 representatives from communities, non-governmental organizations. We're grateful for the work, and we have the current, we had the current Minister of Justice, Mrs. Dobrovolska, in that working group. They were included.
į procesą parengimą projekto, kada bus
in the drafting of that law? Well, when it is going to be adopted and what is the stage? Well, when it is going to be adopted, I don't know. This does depend on me. It was taken over, its drafting and coordination by the Ministry of Justice. And that was a very good welcoming aspect that the head of the working group is current Minister of Justice. So hopefully these processes are not going to last for long, because this is a baby of our current Minister of Justice. When it's going to reach Seimas is difficult to say, difficult to forecast. Currently, we have 4 drafts on national minority laws in the parliament due to political disagreements or different political maybe attitudes are at standstill. But this project will be different, or because it was drafted by a joint working group without representing any party. Hopefully, it will have a better time in basically in the parliament. Thank you very much for your answer. Well, basing on what has been said by the doctor and Mrs. Vaiva, since we are planning to submit that draft this year, can we expect to have the attitudes different? Can we forecast maybe it will receive some negative negative situation, negative attitude. We saw different, the politicians say things, there were some negative things as well. We saw that on our media. Such questions become a tool to achieve political manipulations and so on and so forth. We have to disseminate information what we have or what the drafters have, the Ministry of Justice, and so on and so forth. Well, there were certain things that were blamed. We were blamed for that, and I think that the Minister of Justice is good, that she's a specialist, she knows things, and the communication was really good. Because things were escalated a lot, but the Ministry of Justice is dealing really well because they were at the very roots of that thing. Well, just maybe you could say the main points of the draft law. How the current situation could bring any benefit to national minorities. It's difficult to say.
Liepos mėnesio, nes tai yra metai ir tą reikia suprasti, kad turbūt jisai buvo.
Well, we have to understand that this law was being dealt with, drafted, taking into account the stakeholders, the institutions, but the project that was drafted by the working group guaranteed the minorities to address the municipalities, local authorities in densely populated areas, the right to be considered as a national minority, to change their nationality, to indicate that, because I know that this is a problem. As far as I know, if a person in the registers is indicated as of being of certain minority, and it's very difficult to restitute your nationality if the nationality is different in the register. And for example, the parents were prosecuted. So there are certain special tools, special means, as we've talked about them today. There are certain priorities in funding programs for national minorities, because we often see that national minorities cannot always compete with other players, so all minorities could be considered, could be treated equally. They have a certain score or weight, so to say, the right to be represented, and so on and so forth. I was not ready for that question, so I need to take a look into that. We will talk about that more. Thank you very much for your presentation, for your comment. Well, we talked that this law could cause certain intensification of public attitudes and public mood. Now the question to Birutė Sabatauskaitė: how can we differentiate when the hate speech can reach us, and whether it is discrimination or hate speech? But hate speech, how can one understand when do we face this or another situation?
Ačiū labai už klausimą. Man pirmiausiai norisi pastebėti, kad
Well, thank you very much. I think once we have an issue of rights of a certain group, intensification, we receive different comments. The loan partnership, let's say, was being discussed. When, for example, the issue of writing of personal names is being considered, then people start saying, what do they like? What do they want more? But we have to understand one thing, as that assimilation is not the overall aim when we speak about the inclusion of national minorities being them in the society. And one of the main components is that people could retain their own identity via social ties, culture, and so on and so forth. So I wanted to focus on that. The Court of Human Rights also noticed that the majority dictate cannot be applied to ensure human rights, of the rights of minorities. So I would like to ask everyone to join for really honest discussion. People could have opinions. This not necessarily means the hate speech, but in differentiating hate speech and discrimination, if we have hate speech that is being instigated to also encourage violence, or there is a demeaning behavior with regard to certain group, then the report should be filed within the police, or we should really look into more detailed. There should be assaults on the streets and so on and so forth. And from my previous experience, then working people speak in Polish, for example, or in Russian, or somebody decides to insult them or exert to physical violence, or there is some demeaning, humiliating comment. There was certain cases like that, and not all cases are really focused on or reported to. If the overall background is intensified and it shifts to the workplace, so on and so forth, and the employer does not resort to certain measures to really um, to resort to certain measures, and on the labor market people are being insulted and so on and so forth. Why do you want things go to Poland and so on and so forth? So if this is being done in the workplace and security is not ensured, this is considered discrimination or harassment. This is the difference, and then the Equal Opportunities Ombudsman could be addressed. We're sorry this. Thank you very much for your explanation, because often, especially now, even though we speak a lot about certain things and discrimination and hate speech, we very often find it difficult to differentiate where is the difference. Now I think we understand better what is discrimination and what is hate speech. We have the last question from Dr. Lukas Schwarden, very briefly to Mrs. Vaiva. Could you please confirm that the department is preparing a report on national minorities? And will it be published, and are NGOs invited to give input? Yes, thank you. I think we are talking about the report on the convention of framework convention on national minorities. And the department, together with other institutions, this is not my area. And I cannot say when it's going to be drafted, but by the end of the year we will do that. We will submit it in July, August, but it has to be approved. As regards the involvement of national minorities to give input, the Council of Europe wants to see the shadow report of NGOs, and they, in parallel, together with the public institution information, submit the shadow fifth report on the implementation of a framework convention on national minorities. These are two reports that will be compared, and the Council of Europe is drafting it to the institutions information. And they provide recommendations later on the implementation of the convention. Thank you very much. Such alternative reports are being submitted by our foundations. Now we have a long break. And let us meet at 2 o'clock, and we will start the second act of our conference, and Professor Artur Novak from Warsaw Economy School will start that about the right of languages in the European Union.
Taip pat bus po to jau ir mūsų konferencijos pabaigoje sekanti diskusija. Tikiuosi, kad
we'll have the next discussion, and I hope that we will be able to expand it. So please join that and have a nice lunch. Thank you for your time, for your discussions and presentations. This information was very important to the inhabitants, organizations, and all of us. Thank you very much.
going to speak about continue speaking about the rights of national minorities, not only in Lithuania, but in the broader perspective, namely in the European Union, in Europe, and we'll touch upon international standards. And our first speaker is Professor Dr. Artur Novakvar from the Warsaw School of Economics. Hello, we are pleased to see you here, and we are looking forward to hearing your presentation. The floor is yours.
Yes, thank you very much indeed for for inviting me to this conference. Well, I will start right away, and I suppose my presentation will also communicate or dialogue a little bit with the presentation done by Dr. Vadin, because I will at some moment tackle on that issue too. And of course, I will save of course, your time, because well, that case was or has already been presented in much more detail than I had ever planned. First of all, I would like to say that in the European Union, the language rights are the part of the recognition of diversity, the recognition of unique identity of each nation or each language speaking group. And last but not least, it's also a reflection of a pattern of official effectiveness, meaning that whenever we allow minorities to speak officially in their own language, then we will make the users of that language more effective in the social sphere, which is quite important, because if you are prompted, or if you are compelled not to speak your native language in a certain setting, then you may feel constrained, not maybe with your rights, but with the ability to speak out what you think, to speak out your interest, and that's pretty important. With regard to the equal status of official languages, after Joseph Raz, which is a very important theoretician of law, which we are quite able to say that well, this refers to the equal treatment of individuals. This produces, or is to produce, neutrality of rules of recognition and neutrality of effects of recognition. But the most important part of this thought is that those rights, although we construe them as something which belongs to the group, are to be realized always by individuals, as the case Vadin indicates really, or shows up. It's about the family, about the individuals, and of course we can feel sympathetic to what they are doing or what they are trying to pursue or achieve, but still it's about their own rights, individual rights. The rights arising from the recognition of the minority languages or languages actually is highly embedded in the very idea of European integration. And here you have, well, quotation from what Coudenhove Kalergi have said about that, and that prompts us to conclude that the European integration has never been in contrast or in conflict with the recognition of the minority rights, including the language rights. The EU also is somehow bound in its policy with the higher international norms, like the Universal Declaration of Human Rights, Article 2, which says also about the language rights. The European Convention of Human Rights, which also says that, well, we should enjoy the freedoms pertaining also to language, not only to religion, color, race, sex, but also to language. And well, the very treaty of the European Union also can be considered a basis for it, because it says that the European Union, or the Union, shall respect its rich cultural and linguistic diversity, and shall ensure the Europe's cultural heritage to be safeguarded, safeguarded and enhanced. Well, the European Charter of Fundamental Rights is also about that, because it says that the Union shall respect linguistic diversity, and that any discrimination based on such a thing like language is to be prohibited, which means that, well, we have a fairly well-developed, higher level setting of international law norms pertaining to the enjoyment of the minority rights. However, when we go down into the European Union law, it may be a little bit like more nuance. It's not an across the board freedom which is to be enjoyed by all the people, but rather something which is highly regulated and also very much up to the Court of Justice jurisprudence. There are two basic rules regarding that. One is set forth in the regulation number 1-1958. It's actually the very first legal act of the European Union, still binding, but which has been well changed with consecutive enlargement of the European Union, which says that all the legal acts of the European Union will have to be produced in all the official languages of the European Union, and each of the versions of the European Union has equal value to other versions, which means that there is no controlling and controlled relationship between those languages. In other words, whenever someone says, well, I would refer to the Lithuanian, let's say, translation of the English text of the EU legal act, that is not the right setting. I will be only able to refer to the Lithuanian reproduction of the European Union Act, which is equal to the, let's say, the French or the English version of it. There's no translation, Lithuanian translation of this legal act. Or if we adopt such a picture, then we would be able to say that, well, whatever we have in hand is, and it's written in English, then it's an English translation of the legal text in Lithuanian language, which is a little bit weird, but well, that is the reality which is enshrined in regulation number 1. And the second very basic rule is the Sylphid rule. Sylphid rule arising from the judgment. The name arises from the judgment of the European Court of Justice, which decided once on a rather trivial issue of terminology used in wool business. But regardless, the court here said that whenever we have a legal act in any official language of the European Union, then we are quite able to rely on the other 23 language versions of it, because the European Union legislator speaks out with all those 24 languages which are having the equal status, equal authenticity. They are equally authentic, basically, and we can even compare those versions to get the sense of the legal act. In other words, we are quite able to say on the basis of the Sylphid rule that the legal acts are all simultaneously produced in all the 24 languages, and well, the full sense of the legal act is always a result of the analysis of all those 24 legal acts. But this point is quite important because it really indicates how, I would say, perfect the world would have to be in order to fulfill the Sylphid rule, because it requires actually the users of the EU law to know all the 24 languages, which the requirement, that requirement has never or is very rarely to be met. I mean, I've never met anyone who would be able to speak fluently with high level of competence in all 24 languages, official languages of the European Union. Therefore, when we go to the interpretational jurisprudence, we would very easily discover that the Court of Justice relies on Sylphid rule, but in a very specific way. Namely, it says it's okay to have that sense developed somehow on the analysis of the 24 or maybe a handful of linguistic versions of those legal acts, but we should also rely on the purpose, the objective, and also on the spirit of what's written in the interpreted legal text. The In other words, we can now are able to summarize a little bit of what I have said using the the sense developed or attempted to be identified by Solana. Namely, we are talking here about equality, which is equality of languages, which is pursued most assertively by the European Union institutions, about fidelity, which is to be the result of law interpretation, which should be uniform across the European Union, and the efficiency, which requires that the benefits of the system shall prevail over the cost of it. In practice, EU practice, that is a little bit like a tricky issue because, of course, we have the sense of equality of those official languages. The problem is, however, that in Lithuania you have just only one official language, and that is Lithuanian. Whenever we talk about minority languages, they are not recognized under this umbrella at all. I mean, Polish is equally the official language of Poland, but if you want to speak minority language, let's say Lithuania inthe, then, you are rather using your minority rights rather than the rights which are enshrined in those rules to which I am referring to. In other words, these are the strong rules or the core rules. But with regard to the using of the minority language, there are some other rules auxiliary to the system, which are like lower level rules, mostly enshrined or protected under the international law and maybe the Charter of Fundamental Rights rather than the regulation number 1 or Sylphid rule. Also, when it comes to the publication of some legal acts, we have some practice, which is a sort of a soft departure from the rule that they should all be produced in all the 24 languages, because sometimes when the law pertains only to one nation, to one country, then the law says itself that, this is the controlling and the only authentic version of this law. You have the example of the decision to 2015-826, which is published authentically only in Danish. Also, we have the working languages, which are the French, English, and German. We have the language of EU diplomacy, which is declared to be English, French, and Spanish. And we have the language of the EU courts, where the language of the deliberation, internal deliberation, is French. and the language of specialized agencies. And one of them is, the Agency for the intellectual property, which makes it possible for people to appear only in a handful or act only in a handful of languages. In other words, Polish or Lithuanian would be excluded from this list. Also, the EU practice in member states is a little bit like more diverse and not that uniform, because EU recognizes that the linguistic diversity is a barrier to economic freedoms, and therefore it promotes EU linguistic diversity via making the minority languages protected, and also via promotion of foreign languages learning, also via imposed recognition of essential documents like invoices in the language of origins, but it falls short of expectations when it comes to the national documentation producing practices, as Runevich Varden case straightforwardly indicates. Well, the conclusion of my presentation, of my interpretation of the situation, is that the EU is between Scylla and Charybdis. It represents a flexible yet idiosyncratic approach to those rights. It produces high cost of the multi-language reality. But on the other hand, this solution which has been adopted has a very high legitimacy, because we all like it. We think it's okay to have this diversity promoted. We would like to have it more promoted than it is promoted. Basically, the system is very much in line with the international standards, but it has some backfires, like Runevich Varden case shows. Thank you for your attention.
Ačiū Jums už Jūsų
Thank you for your presentation, taking a broader perspective of EU law. And now let us speak about a specific application of languages in the process of education. And Danuta Šainicka, who is the representative of the National Agency for Education under the Ministry of Education, Sport and Science, will tell us about this. She will tell us about the renewal of the curriculum for the teaching of national minority languages in the context of European language policy. So, hello, the floor is yours.
Good afternoon. I'm very happy to be here. Thank you very much for inviting me here.
Platesniam kontekste, o aš šiandien galėsiu kalbėti labai trumpai apie tai.
Today I will provide you a brief presentation how we renew the education content and what is the work related to this area. I do hope I'll manage on time. So we speak about general curricula a lot. They evoke a lot of discussions usually for the society and for the general public, for the community. You're okay with time? Well, how are the general curricula renewed of national minorities? This is really big work, and from the EU funds, there is a project, the creation of curricula. In order to renew the curricula, this is perceived in a very broad sense. How we are assessing what we are doing, and for that we have a lot of documents. Some of them are renewed. The tools are being updated and created. And teacher qualification development is being carried out. So this is a few-year project. If we were to talk about national minorities, we have lots of representatives of national minorities, but there are 4 languages with the instruction for national minority languages: Belarusian, Polish, Russian, and German. The Republic of Lithuania creates conditions to study in these languages, study the national language as the language of the state, as well as their native language, from primary education to secondary education, respectively, putting 6 hours for primary education, secondary from 5 to 4, and the secondary or basic education is concluded with the assessment of the knowledge of the national minority language, as well as math and Lithuanian language. Then other 2 years we have 4 weekly hours for that. At the moment, the school exam of the end of the schooling period is not compulsory. The students might choose that, or the council of the school can decide. Most often in Russian schools, they choose German or Belarusian language exams. In majority cases, the school councils adopt a decision to take an exam, because that motivates the person, and in this way the identity is retained. At the moment, there are projects for basic and primary education, and secondary education also evoked a lot of discussions. It's great that during the discussions, usually the communities react to those discussions, and in grade 11 and 12, grade in the initial draft, this was considered to be an optional thing. Polish, German, Belarusian really took part in the discussion, and they wanted to retain it as compulsory. Well, also education in national minority languages as their native languages. Well, once we wanted to really look into the situation, we organized a conference to share the experience, and Boguslavas Gruževskis said that education enriches human resources of the country. We are speaking in a few languages. That increases cultural and also language diversity, reduces the closeness of the isolation of the state, and shapes conscious tolerance. Scientific studies show that in such a way, the more multilingual the society is, even though there are lots of challenges, because there are a lot of things to do to retain the society. There are this is one of the main focuses. It is very important to deal with integration problems, to deal with the issues between different languages and so on and so forth, of the state language, and also in ensuring the integrity with foreign languages. As Professor said, this helps to really retain the identity and educate the society. The concept of our program is the program that is based off the competence development and an anthropocentric worldview. Well, first of all, the programs should be based on competences, where not only the subject becomes important, but also the needs of a pupil. And if we were to speak about a pupil, he or she has to be able to communicate in different languages. And if we speak about the competence-based education, we are encouraging non-formal, non-traditional education when different spaces are used, because when learning the language, we can learn it in different spaces. We focus on that a lot. So we have two main goals. For us, it is important to educate pupils in national languages to understand the social cultural aspect. And talking about communication abilities of national minorities, we have to understand that we need to focus on the fact that a pupil has to be flexible in switching from one language to another. It is important that a person should be able to communicate not only in minority language, but in a state national language. It is important for personal development to also help pupils to discover literature and culture for the development of identity. And our aim is that a pupil, when learning, is able to understand not only the national literature, but also understand the cultural and literary ties with Lithuania, social, historic ties, because this is his or her native country. And this is how our tasks are put. The document can be read Mokykla 2030, School 2030 portal. Well, our goals determine the tasks. So the block of value propositions, it's important for us that a pupil understands state language, their native language, perceive the culture and history of Lithuania as an important part of identity, be interested in regional and Lithuanian culture, history, contemporary life, understand intercultural ties or relations. Such value propositions are very important that could help shape the person to become a real ambassador. Understanding Polish, Lithuanian, Polish, be able to represent cultures in Lithuania. And also be able to understand culture and represent it. This is related to the subject competences, which are very important in contemporary life. Understanding the aim, addressee, and so on and so forth. And also to discover oneself or herself in multicultural society. Another block of tasks, as we say, is cultural competences. So understanding cultural phenomena are very important. We want our pupil to be active participant. Literature, culture also passes on different values, and this way shapes identity. It is also a very important part because a lot of integration here is with history.
Nespėja per istorijos pamokas, tai čia turėtų irgi sužinoti.
This should be passed on to during history lessons and help shape the values. Very briefly about the challenges. Education content is perceived as the entirety of social cultural topics and 5 achievement areas. In language education, not only achievements are important, but also social cultural context where people are educated. This is more for linguists. I will very briefly comment on it. Well, language education could be put into the main description of the situation. We have the addressee, an addressant, and we have to look into the tools or means how we communicate, taking into account the aim and the context. And in such communication situations, a person or a pupil will find himself or herself a lot of times, irrespective of the situation. They can be at the conference, watching a play, and so on and so forth. In order to help a pupil to find himself or herself in communication situations, we have 5 achievement areas. So speaking, listening, interaction. We are also learning to listen and to speak, bearing in mind the addressee. Learning strategies are also very important. The comprehension of a text are very important. The abilities are very important, from reading to comprehension. 50% of the success depend on that, whether they can read, whether they can embark certain comprehension strategies, are able to perceive the task, answer the question, and so on and so forth. Text comprehension strategy should be applied. And we need to read fiction and non-fiction texts. Also, creation of the text. It is important to know how to write literary essay, but we also need subject skills and so on and so forth, because this should be starting from primary school. Only the context is expanding. Well, the cognition, the knowledge of a language, to perceive the system, understand how to put everything in a sentence. This is an area of cognitive achievements, and literary and cultural education that helps to shape the identity of a pupil as a human being who understands the roots, culture, and so on and so forth, can compare it with the past. Here you have all subject competences. The first three ABC point could be named as tools that enable a pupil in a communicative situation. And then the others is the context of knowledge, the knowledge that will help a person to also act. In Lithuania, we have 6 main competences. Cultural competence, as well as other competences, such as social, emotional, a healthy way of life, and creativity and civic area. All those competences are described, and there is a development of those. And for us, it was very difficult. It was a challenge to join subject competence with general competences. Here, one might really see which ones are important. Our program is competence-based education, focus on competences, and this changes the shift. And especially writing, reading strategies, because it is from the strategies, from knowing how to learn, determines the success of a pupil. During most years, the topics repeat themselves, because this spiral learning helps you to learn. Every year we are repeating the program of every year, And this is supplemented by more difficult abilities, and this is how a person is growing and learning. What is also important is so to say, grade 8, and this is really coded in our program. All functional things, knowing how to write a notation, a personal letter. Well, sometimes maybe the students are too little, but when employing the literary content, the plot, one can learn better. Because these are very important and complicated abilities. You need to improve these abilities. And so a pupil can really understand that what they are learning at school, they will be able to apply in life. Also, it is important to know how one can switch languages. There is development of the language. One has to avoid language confusion, and this is how phonetics, lexical items are chosen. And language as a social phenomenon is very important. And pupils who learn in Russian, Belarusian schools, they should notice differences between languages. If we have two genders in the Lithuanian language, in the Polish or Russian language, we have three. There is a middle language, so a teacher, when looking into the curriculum, putting the education content, should know how to do these things and notice social phenomena that determine the language. Literary education is very important. Here we see the anthropocentric concept, which is very subjective. Literature, culture helps us to understand yourself, oneself, how I am changing, how the world is changing, what are the values. This causes a lot of discussion because we all have our preferences, what is important to us, what is not. There are lots of discussions on that. That's why we need to focus on that. Contemporary and classical literature has to be compared one with another. Modern versus old, because our modern pupil has to perceive different texts. This has to be literature, architecture, cinema, different texts, and they have to learn how to read those different texts, how to interpret them, assess them, these abilities, these achievements are very important. So this is why we focus on general competencies, not only linguistic. Back in 2018, there was a meeting with Polish experts from Krakow Pedagogical University who shared their experience, how they basically draft curriculum based off anthropocentric cultural and literary concept. It is a very symbolic picture with Lithuanian, Polish, German, and foreign language teachers who wanted to hear about the concept of literary education. Now let me demonstrate how this concept is implemented. Here you see a brain map. Cultural text and literature is chosen with regard to the analyzed topics. There are topics, problematic thinking, and only then we are analyzing the ideas in the literary era. And then we have text selection criteria. Well, it was decided to abandon the compulsory list of literature from grade 1 to 8. There are lists, but they are recommended, not the ones that are a must, compulsory. This is why we wanted, and how we wanted to give more flexibility to a human being, and a pupil, so they could react flexibly. Here we see an example from Russian language. If a topic is on artists, one can read classical texts of Gogol, watch a movie, and also look at the works of art of Dobužinsky, and also the ties to Lithuania. And in such a way, a pupil looks at the topic from different angles, develops thinking, and is learning to be not only an observer, consumer, but a critical, develops critical thinking. A participant of literary cultural life. Mrs. Šeiniecka, maybe you could start wrapping it up, because we have other speakers. I will not show and comment all examples.
Only I'd like to underscore the cultural awareness and cultural life participation, because it is this participation that allows to develop all competences and skills through project activities and inter-school events, cooperation with various institutions, and all of this should allow pupils who learn a national minority language to become an ambassador of the culture, literature, language, and the nation, and would be able to find his or her place in Lithuania. However, there is always a question whether we always use the possibilities adequately, because there are many declarations and statements that multiculturalism and multilingualism are advantages, but it is not always that we use them correctly. So this is food for thoughts for the future, namely how we could use the potential of these pupils. Thank you very much. And if you have questions, you can write to me. And if somebody got interested in these documents and would like to read them, they are available at the portal Mokykla 2030. Thank you very much. Thank you for your presentation, really in-depth presentation. We will come back to the topic of education and languages during the discussions. And now I'd like to give the floor to Dr. Ljubica Đorđević from the European Center for Minority Issues. She will tell us about the outline for the assessment of minority representatives and participatory bodies.
Thank you very much. Thank you very much, Barbara. Thank you very much for your center for inviting me today, but also I would like to congratulate you on the 10th anniversary and to compliment for your efforts and to commitment to human and minority rights, and just give you my support to do as you did before. So go for it. Today, I want to share with you some methodological considerations about minority bodies and how effective they are and which impact they make on minority everyday lives or welfare. Because as you all know, legal framework is one important prerequisite for minority protection and also in this context minority participation. But what counts more is what is in practice and how this can be implemented in practice. And now I want to share my screen with my presentation. So I hope you see it. The very grounding idea is participation, and the role of participation as one of the core pillars of minority protection. As you know, participation has two important roles. One role is to protect identity in terms that minority or minority representatives can make decisions or effectively participate in decision making in areas which are pertinent to minority identity. But the other aspect, which is also important for participation, is that through participation, actually minorities participate and integrate into wider society, although integration is, as we know, multi or double side street where also majority is involved. But nevertheless, so participation enables that minority can participate in wider society and be part of wider society. In these terms, Article 15 of Framework Convention is the core provision on the European level, and participation is taken as one of the main areas also when monitoring implementation of Framework Convention standards. What is crucial for assessing participation or quality of participation is the effectiveness. So how effective is participation? So it's not enough to have minority representatives in some body, but also that their voice can be heard. So it's not as simple that you have, I don't know, 3 MPs, or you have some consultative body, or you have 3 vice minister or so on. It's also important, so like a window dressing, it's also important that this participation has some impact on minority protection and that these voices are really heard when decisions are made. So there are various channels for minority participation, and today I'm focused on one specific aspect of minority participation, and this is this is minority representative bodies. In some instances, these bodies can make up to autonomy, personal autonomy. For example, in Hungary or in Serbia, we have minority councils. In some other instances, they can be purely consultative bodies. But as we heard also today about the council in Lithuania, so they, depending on their structure and their competencies, they can have form of different, or they can have a different strength of influence on decision making. So what are methodological considerations? So what I want to present today is actually methodology and how we can improve monitoring and assessing the effectiveness and impact of these bodies. With this methodology, which is a first step, and the second important step is then data collection and assessment and monitoring and assessment. So we can help different stakeholders to actually monitor the situation, but on the other hand, the ultimate goal is actually to improve quality of participation through these monitoring bodies, to improve their effectiveness and their impact. So the goal is actually to evaluate their performance and to see how they contribute to minority participation. How we can do this? We can do by identifying strengths and weaknesses, and then to help them by identifying strengths and weaknesses, to identify them, to help them to build capacity, to strengthen accountability, and to have some kind of standard in performance, which is often lacking in many of these bodies. So how can we actually monitor these bodies is through evidence-based recording, so that we actually, and this is something what advisory committee on framework convention is now pretty much into it, is that reports of states, and also shadow reports, but reports of states are main party which are responsible for implementation, that they are not just narrative, but they also provide some data on which these narratives is then grounded. So it's important that it's not only about feeling how they perform, but actually to have data on which we ground assessment of whether they perform or not perform. In this respect, it's important to combine quantitative and qualitative indicators, which are mutually supportive, because if you have only quantitative, then you cannot get a bigger picture, or you can make conclusions which are wrong, or you can have much data which is actually not offering information. On the other hand, only qualitative, as I said, can be just narrative without grounding data. Then the question is how detailed we want to monitor in order not to have bulk of information which is actually misleading and doesn't lead us to the expected goals. And on the other hand, it's also important to have reliable data collection, but which is not formalistic. It's not just that you have a checklist, meetings, and this and this, and you just click the box, but in the end, you cannot make a real assessment of the situation. The question is who are the actors? The actors are, first of all, the minority bodies themselves, and they what is the idea is actually to create the standard of action plans, reporting, and so that they monitor own work and see how effective they were, and what were the challenges and causes for the challenges. Of course, state institutions in scope of their regular reporting and monitoring. International monitoring bodies, again, I mentioned advisory committee, which also when assessing Article 15 also explores the capacity and impact of this kind of minority bodies. Of course, civil society, you are a good example of this, and us research centers. So, and finally, risks. What are the risks? Risks are insufficient human capacities, especially within these minority bodies, because this is a ambitious endeavor that you record all your activities and record the structure of your members and all this. So the question is whether we are realistic and whether we have sufficient human capacities who will engage in monitoring. There is also a risk of obstruction because often these kind of bodies or people sitting there wouldn't like to have a mirror where they see how ineffective they are. On the other hand, maybe state can also obstruct because the problems in ineffectiveness can be because state is not responsive, that the body actually comes with proposals, comes with strategies, but the states actually blocks and make then these bodies ineffective. And another risk is again that this process doesn't lead to an effect, because this process in the end shouldn't be like a philosophical practice or philosophical exercise, but should lead in the end to the improvement of situation. So it's not aim as itself, but it's a method which should improve. It should improve situation in a second round or in second. So the core area or core question of this methodological endeavor is what are the areas or in which we can develop further indicators on ground of which we can assess minority bodies. And here I have developed 5 clusters of indicators. I mainly used as a case studies some examples in the Western Balkans, because this is the region I come from. So Serbia, Croatia, Montenegro, partly Hungary, all these countries, and Slovenia, all these countries have some kind of minority self-government institutions. But then some of these indicators can be also applied to consultative bodies which exist, for example, in Czech Republic, in Slovakia, but also today mentioned council in Lithuania. So although they are different in nature, but through these indicators we can also identify the difference in nature and impact, and on the other hand, to what extent these differences influence their impact. So I identified 5 clusters: institutional capacity, competencies, funding, cooperation or networks, and transparency and accountability. Whereas I find that competencies are really the core area. What powers these kind of bodies have, how they can act, and the other clusters are actually only supportive and of course influence the capacity of these bodies and their impact, but the core is competencies. So here only briefly I will go through the indicator clusters. So, and just because of time, just identify the core areas. So when it comes to institutional capacity, one important aspect is legal whether the body is constitutionally entrenched or in the law or in governmental ordinance or war. So the stronger this legal basis, the institutional capacity is then stronger. Important is also the the structure in terms of membership, in terms of representation, gender, age representation, because one of the core questions about these bodies is their representativeness. Because not only in theory, but also in practice of advisory committee, representativeness is considered as an important aspect of effectiveness. So if it's not representative enough, then it cannot be effective participation. One of the core questions, unfortunately, we don't have time to go into it, but it's very, very interesting, is about membership. And not because you know that this membership in national minority is generally subjective, but who can vote if it's about voting, who can vote for members of these bodies, who can candidate. And there have been a lot of interesting cases, for example, in Hungary, but court cases in Finland when it comes to semi-parliament about who can vote and who can be elected to sit in these kind of bodies. Important thing is also administrative support and employees. So everyday functionality of these bodies, if they have employees, if they have some kind of secretariat, and so on and so forth. And then the regularity in institutional functioning, that it's not that they meet every now and then, but that they really meet on regular basis with agendas, with developed strategies, action plans, and so on and so forth. Another so the core aspect is our competencies. And usually it is a standard that these bodies or their mandate is limited to national minority core issues, education, culture, media, language. So the question is, how broad are their competencies? Because this also determines their impact on everyday life of national minorities or minority they represent. Then the core question is the quality of powers. Can they have do they have the decision-making prerogative, self-rule? Can they decide on something or make decisions for the national minority, which is the case in autonomy arrangements, that they decide on curricula, that they decide on structure of schools or network of schools or museums or something like that? Or they have shared rules that they can, for example, veto a government decision, or that they can propose something and government cannot or state cannot accept, can make a decision without the proposal coming from the body. Or in the least or weakest arrangement, that they can need to be consulted when decisions are made by the state authorities, be it national, regional, or local, whereas this consultancy is not obligatory, in terms that, okay, consultancy as such or consulting can be obligatory, but the opinion of this body is not obligatory for the decision maker, which is the state. Then the question about, which is when it comes to autonomy arrangements, is very important, is management of institutions, meaning schools, meaning museums, libraries, so to what extent they can impact, influence management of institutions, which is again more the case with autonomy or quasi-autonomy bodies, and less when it comes to consultancy. But even when it comes to consultancy, to what extent consultancy is involved when it comes to management of institution. Another question is about decision making in curricula, textbooks, so education, protection of cultural heritage, media programs. So to what extent are they involved, be it that they can make self-rule or shared rule, or which need to be obtained. And one important thing which I want to make here is a locus standi, which means that they can initiate court procedures or other procedures, not only in their capacity, but also in the capacity of national minority, which is relevant in some occasions and was a question, for example, in Serbia and other countries in the region. And to what extent this position can be used to strengthen the position, the protection of national minorities. So to use this legal or court access to justice as a tool to increase the quality of minority protection. One important aspect is the funding, so it's also one of the core, because without funding they cannot work. But the core question is, on the other hand, not to make funding as a source for ethno business, that actually they are just or minority elite is misusing this channel to extract money from the budget and then distribute it, which has also been is the case in some instances. So that actually how they then manage finances, so do they get enough finances, and then how they manage and how they use these usually state budget funds to improve or to support minority identity, be it education, be it culture or language or so on. Cooperation networks, so just briefly, because I don't want to take too much time of yours. So this institutional networking is also very important because it improves and supports effectiveness. Because as I mentioned, first of all, communication with the state authorities, who are usually the main decision makers, but then also communication with minority, communication with the majority, which is all very important but often neglected, because these bodies should also serve to build bridges with the majority and other communities. International cooperations with monitoring bodies, for example, shadow reporting and so on and so forth. And again, finally, one of the core aspects is transparency and accountability, which has often been on the table in many countries, with the argument that these bodies are often somewhere so too distant from the minorities, that they often don't know who represent them, what the purpose of these bodies is. So one of the question is this strengthening the link between minorities and this kind of bodies. So is one of the core, also one of the core set of indicators in this area, to what extent these bodies are transparent and accountable to people whom they represent, but also accountable in general in this democratic control to the whole society. And finally, my concluding remark, and when we do assessment of minority bodies, we need to have in mind always the general context, and that there are different aspects which influence their effectiveness and their impact. So they're not a big bubble and isolated. So their effectiveness often depends on their performance or underperformance, but often it depends on the wider context, be it legal context, be it political context, so the power structures in the society, national, regional, or local, demographic strengths. So you cannot compare minorities of 100,000 and 10,000. Their capacities are different. Human capacities, financial capacities, economic. So again, the capacity also influences the performance. So this wider context has also to be borne in mind when assessing effectiveness of minority bodies. In the end, so the idea is not just to look into what is in the laws, but also what is implemented, what is the level of implementation, because we experience on many spots in Europe nicely worded laws which are then implemented in non-minority friendly environment. So the question is, and this was actually the main idea of this presentation, to show that the importance of monitoring how regulations are implemented, and not only to ad hoc monitoring, what we do from time to time, but to establish regular monitoring of implementation of, in this case, participation and performance of minority bodies. Thank you very much.
Ačiū Jums už Jūsų tikrai labai įdomų
Thank you very
pranešimą.
much for your interesting presentation about the minority representative participatory bodies, the structure and the aspects that influence their work and how this could affect the legislation. We are a bit pressed with time, but we would like to hear all speakers. Now we will hear about the situation of legal minorities in the Czech Republic. Dr. Mrs. Vasilevich from International Center for Ethnic and Linguistic Diversity Studies will present that. How legal acts regulate the protection of minorities in the Czech Republic.
Hello, thank you very much for having me, for inviting me, and to have an opportunity to share with the case studies of the Czech Republic from the perspective of the implementation of the legal regulations pertinent to the national minorities. I will try to share with my presentation. Unfortunately, there was a technical problem that the file got corrupted, but I still believe that it will be possible for you to see and to follow it. And I will try to be very brief. Unfortunately, I will not be able to tackle all the aspects that would present the situation in full, but at the same time, I think I will tackle the most important aspects that would give you some perspective of the situation in the Czech Republic. So starting for those who are not very much familiar with the situation in the Czech Republic, the main legal acts, a part of the constitution, which is Ustava České republiky and the Charter of Fundamental Rights and Freedoms, Listina základních práv and svobod. There is the special legal act on the national minorities with regard of the persons belonging to the national minorities enshrined in the law number 2073 from 2001 on the rights of the members of national minorities and the amendments to some acts that were adopted on the 10th of July 2001. A part of that, the Czech Republic ratified the Framework Convention on the Protection of National Minorities and the European Charter for Regional Minority Languages. And according to the last one, the German, Polish, Romani, or Roma, Slovak languages were considered as the minority languages from 2007, and in 2015, the two more languages were added to the list, which is Moravian and Croatian. Coming to the basically the law on the national minorities have a number of articles that I would like to address today. I will just list the most important ones, but unfortunately I will not be able to cover all of them. But I think the most important ones are the rights of using names and surnames in the language of the national minority, the rights of multilingual names and denominations, rights of using the languages of the national minorities in the official documents and discourse and hearing before the court, rights of using the language on the national minority during the elections, and the rights of education in the language of national minorities. And the last but not least, the rights of spreading and receiving information in the language of national minority. Today, I will try to focus on the following aspects. First of all, I will talk a little bit about participation. I will discuss or present you the advisory body in the Czech Republic, which, according to the official evaluation, quite successful one, though as usually there are some challenges with the respect of that. Then I will switch and talk a little bit about the most recent development with the census and look at the census of 2021 with the perspective how many national minorities were treated and included into the census. And then I will talk a little bit about the education, and if I have a little bit of time, I will talk a little bit about the segregation and the education. But starting with the participation, the government of the Governmental Council for National Minorities is the advisory, initiative taking and coordinating body of the Czech government for the matters of policy towards national minorities and their members. This governmental council consists of both representatives of public bodies and minorities. And the latter, the minorities, represent of at least half of the council members and nominated by the associations of members of national minorities. As correctly mentioned by Lubica in the previous presentation, that's the most important aspect to address and to consider how minority representatives are selected. And it is never an easy process, and it always has lots of discussions and debates. And the Czech Republic is not an exclusion. And since I've been included into this council for quite some time as the sort of observer without the voting rights, I could say that it was an easy task in order to find the proper representative, the one that would be recognized by all the nation, by the all representatives of the particular nation minority. Another aspect is quite some time, it's low interest and low activity in order to be represented, and also the facts of the different perspective of coming from the same national minority. At the same time, the council composition and nomination of the members is a subject of a special statute approved by the national government. The council includes the representatives of 14 national minorities, which are Belarusian, and this is the proper way to pronounce this adjective, Bulgarian, Croatian, Hungarian, German, Polish, Roma, Ruthenian, Russian, Greek, Slovak, and Serbian, and Ukrainian and Vietnamese. Those representatives are usually appointed and dismissed by the governments on the basis of nomination proposals made by the minority organizations to the chair of the council. The council's term of office coincides with that of the government, and each individual representative of the national minority in the council is limited to 2 consequences terms in his or her capacity, and this list of nominates is exhaustive, although it is a subject for possible changes as the expansion of the government for national minorities through inclusion of the representatives of a new recognized national minorities, which were Belarusians and Vietnamese. That was the most recent case in 2013. The council as whole represents 31 members and appointed by the governmental resolution. I will not list all the ministries included into that, but you can assume that the most important ones are included. And this system is also quite successful with the governmental grants for the activities supporting the development of national minorities and minority languages. Speakers that are represented by the Governmental Council for National Minorities. What is important to tackle upon is that the government annually provides the budget and the competition goes within the national minorities. But when Belarusians and Vietnamese were included into the list, they got the preferences, and the first year they got the finances without going through the competition. What is also important to know about these governments that they have regular meetings and they have the rights to provide the opinion on the certain legal aspects Obviously, it's not obligatory to be considered, but they've been quite active, and it's quite rare that some representative would not attend it, so they take it quite seriously. So this is very short about this advisory body. Another aspect that I would like to underline, the political participation of the national minorities in the Czech political life. And so far, there are 2 ethnic Polish members of the Senate. One is representing Karvina, Andrzej Fiba, on the behalf of ANO party that was elected in 2020, quite recent one, and his term would end in 2026. And since 2016, Jerzy Konchela represents Frýdek Místny County on behalf of the Občany Spolu Nezávislí, the regional citizen initiative, and then represent the interest of the region. It's quite interesting also to mention that in 2018, the half Syrian person became a member of a Senate, and he became a member of the permanent delegation of the Parliament of the Czech Republic to the Parliamentary Assembly of the Union of the Mediterraneans. However, apart of these individual members, with the national minority backgrounds, there are no ethnic parties in the Czech Republic. If we go and look at the recent census that was just recently finalized, that lasted from 27th of March till 11th of May, and it's quite interesting because it has quite a number of initiatives. First, and I think this is the most important aspect to be addressed here, is that the draft material about the census was aimed to explain to the national minorities why it is essential to list the minority nationality during the census. And they give the example that according to the law on municipalities, in the case if at least 10% of the citizens living in the municipality territory would belong to certain national minorities other than the Czech one, then the municipality would establish and have to establish the Committee for the National Minorities. So they were actually advocating people to underline then the national minority background, which was not the case of the previous census of 2011. And also during the census, it was possible for each person to list 2 nationalities. We don't have the results proceeded and presented yet, but it would be quite interesting to see how the aspects of the 2 nationalities listing would be presented. And at the same time, it would be quite interesting to compare it to the similar situation with the recent census in Poland, where they have quite a debate about which minority, which identity, or which nationality mentioned the first or the second would be the come as a priority and how to calculate. But at the same time, what is also important about the census is that this year, this census was online, conducted online, and published in 7 languages besides the Czech one. It was also possible to obtain translations for those languages to comply, to accompany the papers forms which were initially in Czech. In addition to the Czech language version of the census, people were able to complete census form online in English, which is not an national minority language, German, Polish, Roma, Russian, Ukrainian, and Vietnamese. The information for the minority organization was drafted by the Czech Statistic Office in collaboration with the Office of the Government. So the Council of the National Minorities advised to the government on that matter. And also the households who didn't complete the online census form were receiving the paper from the census commissions, and that was provided in the Czech language. Also, the translation to the 7 languages were also available on the website of the census, and it was always possible to acquire the copy of the translated form from the census commissioners at the census contact points. That was short about the census. Then slowly go into the names and surnames. Pursuant to Article 11 of the Framework Convention for the Protection of National Minorities, the Czech Republic undertook the right to recognize that every member of the national minority has the right to use his or her name, father's name, patronym or paternity, and the name and the majority in the minority language, and the rights to the official recognition of the maintainer determined by the law. The patronymic is placed in the position of the second name, should one require that. Also, at the request of the citizens of Czechia, his or her name could be written in the Czech language form or in the form of their national language. Also, the declaration is made before the registry office competent according to the place of permanent residence of the person, or the registry office on those books of the birth of the name is entered. Now I will switch, because we don't have that much of the time, I will switch and to dedicate most of my time to the topic of education, which I find quite interesting and the most challenging one. Access to the education and the language of national minorities is supported on the part of the state through the grant programs, primarily the support of the educational activities of national minorities by the Ministry of Education, Youth and Sport. The associations of members of minorities also actively contributes to education in national minority languages. The School Act allows the introduction of minority language education either on the initiatives of the Committee for the National Minorities or by the decisions of the school director upon the request of the pupils or their parents. For example, in reports from the members of national minorities that was presented to the council, and this is also quite interesting to know that they have to, each national minority has to submit the results and of the activities through the year to the council, and it's done annually. And based on this information, the report on the situation of national minority is published annually. So based on this report, the establishment of the Sunday schools with the teaching in Bulgarian in the city, and the second biggest city in the Czech Republic, Brno, is mentioned along with the Saturday schools established by the Ukrainian or Russian minorities. Also, the Greek minority also presents the provisions of teaching on the minority languages as a challenge, as a problem. One of the most promoted minority with the possibility to study in the native language is the Polish one. Polish is used as the language of instruction in preschool, primary, and secondary education. German as the language of instructions is presented in primary and one state-owned secondary school and in a few private institutions. At the same time, in the light of the small number and dispersed national minorities living in the territory of the Czech Republic, national minority schools only exist in relation with the Polish minority in the Moravian Silesian region. Romani or Roma language is taught only in 2 institutions and is not a language of instruction in any of the schools. The initiatives to launch the primary education in Slovak remain quite unsuccessful due to the lack of parental interest, since the Czech language and Slovak language, they are similar in a way, and there is no problem of understanding both of them. So those Slovaks living in the Czech Republic prefer to send their children to the Czech language schools while speaking Slovak at home. And that was the issue of the certain indirect, I cannot really say there was a direct discrimination based on the language, but there was certain tension between, for quite some time, certain tension between those speaking Slovak language and not pronouncing certain letters or certain sounds properly, and therefore Slovaks living in the Czech Republic, they tend to learn the Czech one. Also, besides the research on the nation minorities, minority languages, universities also provide a wide range of Polish, Slovak, German, Romani, and other Moravian Croatian-related subjects. Now coming to the most debated and issue topic of the situation with Roma and education for Roma. The Roma integration strategy was adopted by the Czech government and focuses on the appropriate teaching of Romani and Czech for Romani children. In the amendments of the School Act from 2015, they established a new system in support of children with the special educational needs based on the inclusion in the mainstream education. And these obligatory preschool classes have been introduced. These amendments of the School Act introduced the compulsory year of preschool education from 2017 to 2018 school year and contributes to desegregation of Roma children. This education is free of charge and expected to help to eliminate the risk of unjustified Roma pupil segregation. And I think that it's important to underline and to tackle your attention. I don't know how much time I have. Barbara, do you have enough time?
Na, dar kelios minutės.
Several minutes. You have several minutes.
Okay. Okay, perfect. Just to then I will stop sharing the screen. So basically, the situation with the Roma education and education of Roma minority was, I am pretty sure that all of you are aware about the very ill segregatory policies towards the Roma pupils in the Czech Republic that ended up as D and H versus others in the Czech Republic case that was brought to the European Court of Human Rights. And according to this case, it was proven that Romani students back then were 27 times more likely to be placed in the schools for mentally disabled children rather than non-Romani peers. However, since this decision was taken in 2007, in 2014, despite the fact that less than 3% of the Czech population is Roma, there were 6 times more Roma children placed in so-called practical schools, and about 40% of Romani children factually have studied in segregated schools with reduced educational curricula and program. And basically, the Czech Republic has been continuously criticized for not improving the situation. There were a number of the conclusions. For example, the Roma index, inclusion index from 2015 was actually addressing and saying that the situation of Roma has improved and the gap between the Roma and the population has decreased. However, the Czech schools remain highly segregated, both mainstream and special education. And basically, due to this fact of this segregation, that's actually the reason why the Roma parents are not inclined to have the classes with the Roma language to be as a language of instructions, because they see that as an additional attempt to segregate their children from the mainstream education, and also the need to for their children to learn and to speak Czech language. Also, European Commission has expressed its concern that almost 7 years later of this landmark decision, DHA versus and others versus the Czech Republic continued to breach the European Union anti-discrimination law and still remains socially and politically embedded structures of discrimination against Romani children. However, to skip the story, since we don't have that much of the time, the first actually step in order to fight against this segregation was this adoption of the School Act that allowed this additional year for the Romani students to study before entering the schools to sort of eliminate the gap, because most of the Romani children, they do not attend preschool education, and in many cases they speak exclusively Romani language at home, so in many cases they are not very fluent in Czech one. And this is the first step in order to overcome these differences. However, it was introduced only in 2017, 2018. We cannot really say that there has been any proven success, because basically just after a year and a half, the COVID erupted, and according to the recent reports, the COVID pandemic actually intensified the already significant differences in the access to the education, because the Roma children didn't have enough technical support and sufficient support for the distance learning, as much as the absence of technology and parental support. So this is very, very quick and short. I hope it gave you the perspective of the situation in the Czech Republic. However, if you have more questions, I will be more than happy to answer them during the discussion session. Thank you very much for your attention.
Thank you to Dr. Hanna Vasilievich už the Czech examples, and during your presentation I have noted to myself several examples. I do hope that during the discussion we will have time for questions and discussions of certain aspects, namely comparing the situation in the Czech Republic and Lithuania, about the spelling and the census. Meanwhile, I am once again sorry that we have a certain change in our program. We would really like to hear the presentation of Dr. Fernando de Varen. He is the United Nations Special Rapporteur on Minority Issues. Hello, I'm very pleased to see you here today, and we are eager to hear your insights.
Thank you very much, Barbara. Distinguished guests and experts, ladies and gentlemen, good afternoon, everyone, or in my case, good morning. Please allow me to first express my gratitude to the European Foundation of Human Rights for the pleasure and the honor of being with you, even if it's only online, for this international conference. There are actually 2 points which I would like to raise, if I may, for the next few minutes. First, that while the protection of minorities, both in Europe and the United Nations, are anchored in human rights, there's a conceptual difference between the human rights as usually understood and formulated in Europe and those as understood in international law at the United Nations. And there's a significance with these differences, which I'll explain in a few moments. Secondly, another point I'd like to raise is that the human rights of minorities at the international level, and I would say the European level, is still an unfinished story. And an unfinished story which all of us need to work together to ensure it will have a happy ending. Though in truth, it should be said that all human rights are also, in fact, a never-ending story, which need to adapt and evolve, as do all of our societies over time. So the first point is that the concept of minority rights in Europe focuses mainly around the rights of national minorities. And this is recognized, for example, even in the title of this conference. And it's also recognized, obviously, in European institutions, instruments, and mechanisms, such as the Framework Convention for the Protection of National Minorities, and the OSCE High Commissioner on National Minorities, once again. We at the United Nations recognize, in fact, 4 categories of different minorities. We actually do have distinctions between national, ethnic, linguistic, and religious minorities. And as I point out in my last report in 2020 to the United Nations General Assembly, the distinction between the 4, well, we have to admit it's not always very clearly set out in United Nations documents, and each category is not airtight, or it's not fixed permanently. There is overlapping, and individuals may, of course, have multiple identities which may change over time. Nevertheless, at the United Nations, the 4 categories of minorities are not considered identical from a legal point of view, which means, well, to put it in simple terms, it means that not all linguistic, religious, or ethnic minorities are necessarily national minorities. There are differences. And this can mean that the rights which may be claimed are not exactly always the same, of the same nature. Now, to put differently, in Europe, you almost always talk about national minority rights, including in your treaties and national legislation. To be very clear and perhaps very blunt, we at the United Nations do not do this. We focus more on ethnic, religious, and linguistic minorities, and they're not the same, as I said earlier. For example, both as as the United Nations Special Rapporteur on Minority Issues and the UN Human Rights Committee, we have interpreted the Covenant on Civil and Political Rights as meaning that even, for example, a Jewish or Muslim tourist or migrant in a country in Europe can constitute a member of a religious minority. So they are members of a religious minority, even if they're actually quite temporarily in a country in Europe. Well, in the case of Europe, there are in fact very few who would suggest that this Jewish or Muslim tourist would be members of a national minority. But for us at the United Nations, clearly they are members of a religious minority, even if they are not necessarily a member of a national minority. And these differences do have concrete substantive consequences. The application, for example, of the right to equality without discrimination can mean that national minorities, as we would tend to understand in international law, must be treated differently from a tourist or a short-term migrant worker. And therefore, that in the application, the implementation of their human rights to equality, it means that, well, it would be unreasonable and unjustified, and therefore a violation of the human right to equality without discrimination for a government not to use the language of a national minority in education or in accessing public services in their own language in certain contexts. But on the other hand, not to use a migrant language in public education when it's spoken by a very small number of individuals who are only in the country for a short time would not necessarily be discriminatory. It would not be discriminatory, since it's not unreasonable or unjustified for state officials in those conditions not to use this language of a short-term visitor or someone who's not been in the country for very long. So particularly, and perhaps to give another illustration, particularly at the level of the public and political participation of minorities, there is a significant effect in the distinction between national minorities, which we do make in international law and which you insist on in Europe, and other ethnic, religious, or linguistic minorities that are to be made in international law. So there are distinctions between the formulation of national minority rights and how we at the international, the first one is in Europe, and how we at the international level formulate national, ethnic, religious, and linguistic minority rights in international law. And I would invite you to keep that in mind, as it can have some concrete significance in the protection of members of different minorities in different contexts. So that's what the first point I wanted to make. The second point is that the protection of the human rights of minorities is an unfinished story, as I said earlier. We tend to forget that, historically speaking, human rights from an international point of view only emerged after the Second World War, and to a large degree as a reaction, almost a guilty reaction, as a matter of fact, to the atrocities committed during the Holocaust against mainly, not exclusively, but mainly Jews, Roma, and others who were often and even mainly minorities targeted for genocide. Now, despite this, and for reasons that I have to admit are too complex to discuss here, the European and international legal systems to protect the human rights of minorities are timid. They are also underdeveloped compared to many other segments of society. If I needed to remind you, let me point out that the Council of Europe was in fact unable to agree to a fully legally binding treaty when it adopted the Framework Convention for the Protection of National Minorities. And that might sound surprising, but please give me a few moments to explain. That treaty, which the Council of Europe and all of us should be proud of, is still only a framework convention. It's a framework, not a more fully applicable treaty. And while we could argue the significance of this, there is a difference between a convention and a framework convention. And it was at the time, and it still is, I would suggest, an unwillingness to extend more demanding legal obligations on states when it came time to recognize and implement the legal recognition and enforcement of the human rights of minorities. If I needed to remind you, let me bring up the issue of the Minority Safe Pack initiative at the European Union, which would have led, and notice that the qualifying language that I use, would have led to the strengthening of the legal protection of and access to services for minorities. And despite being backed by a petition of almost 1.5 million citizens, and the actual backing also of the European Parliament, the Minority Safe Pack initiative has, in a sense, summarily, very briefly, been rejected by the EU executive as essentially not being necessary. We're not necessarily better, by the way, either at the United Nations. There is almost no legally enforceable mention of minorities in our legal documents in the United Nations treaties. As I said earlier, the protection of the human rights of minorities is very much an unfinished story, which all of us need to work together to ensure it will have a happy ending. But in a sense, it's part of a normal, or I would say normal evolutionary process. Keep in mind that after the Second World War, it took time. In fact, it took a number of decades for us to actually develop the human rights treaties, and particularly treaties to protect and elaborate on the human rights of segments of society that were probably particularly vulnerable and marginalized. Refugees, indigenous peoples, children, women, migrant workers, and persons with disabilities have all had their human rights further developed in treaties at the United Nations between 1948 and 2006. This is an evolution. It didn't happen immediately after the creation of the United Nations, but there was recognition that the general human rights standards had to be refined or elaborated, explain more what, for example, the right to equality without discrimination means for persons with disabilities. I'll repeat it again. Refugees, indigenous peoples, children, women, migrant workers, persons with disabilities. They all have treaties at the UN now. The one group missing in this global evolution are minorities. Minorities in the sense that they remain the only, I would say, the only vulnerable or marginalized group excluded from a more detailed enumeration of the content and protection of human rights as would normally occur for particularly vulnerable groups at the United Nations. Now, this is something, as I said, which is an unfinished story. And I hope this is, at this time, it is something that we will be working together. All those who believe in the universal application of international human rights in Europe and elsewhere need to actually acknowledge this gap and work together to try to address it. Now, I know my topic is whether there's a difference between the human rights of minorities and national minority rights, but I hope you'll forgive me if I now take a few minutes of my allocated time to mention again that last year was the 10th anniversary of the European Foundation of Human Rights. And I mention it because, of course, the pandemic meant that it was not possible for most of us to be with you to mark that moment. And by the way, if I remember correctly, I think I participated in 2013 in my first training session after the establishment of the European Foundation, a few years after its establishment. And I must say, I have participated in many of the activities. I'm very pleased and privileged to have had that opportunity, and I hope to be able to do that again in the future. But what I'd like to therefore take this opportunity to celebrate and congratulate the European Foundation of Human Rights and all of those who have been involved, including its founding director, I think, Lukas Vardin, and also Evelina Dobrovolska, with whom I worked when she was early on at the European Foundation, and she is now, and congratulations to you, Evelina, Minister for Justice of Lithuania. All of those who over the years have, by contributing tirelessly to the activities of the European Foundation, have also contributed to strengthening the protection of the human rights of minorities, not only in Lithuania, but I would say also in the Baltic region and in Europe. And as we say in French, chapeau, congratulations to you for what the world needs now more than ever, which is helping to achieve justice through human rights for those who too often in the world remain vulnerable or marginalized because their fundamental human rights, such as to equality and without discrimination, is too often ignored and disrespected. And I would finally, in this spirit, like to take the opportunity to invite the European Foundation to be actively involved and to consider how best to contribute next year in 2022 to the 30th anniversary of the United Nations Declaration on the Rights of Persons Belonging to National or Ethnic, Religious, and Linguistic Minorities. Next year, under my mandate, we will be holding a series of regional forums and discussions on the future, on how to improve and strengthen the protection of the rights of minorities after 30 years. And we will also be assessing where we're at after 30 years of the adoption of the Declaration in terms of trying to better recognize, protect, and implement what are the human rights of minorities. So I hope not only that you'll be able to participate in the events of my mandate on the Declaration, but that perhaps we can explore in ways where the European Foundation could be directly involved in activities with me and the United Nations to mark that celebration in order to always try to improve and to strengthen the protection of the human rights of minorities. And on that positive note, I hope I will end by simply saying, Dziękuję, ačiū. Thank you.
Ačiū Jums iš tikrųjų ir už Jūsų pranešimą, ir už kvietimą dalyvauti būtent 30 metų.
Thank you very much for your presentation, for your invitation to take part in the 30th anniversary. We would be happy to take part and we will be able to present the developments on our side. In Lithuania, within those 30 years, things have changed. A lot has changed. First of all, the state has changed, and the changes that were brought about were going towards the maturity of the public. There was political maturity. So we will be happy to share our experience with you. Now, let me give the floor to the last but not least speaker today, whose presentation was really the one we've been looking forward, Dr. Agnieszka Sklenda, Secretary to the Committee on Human Rights and Legal Affairs in the Council of Europe, who will speak about rights of national minorities in accordance with the guidelines of the Council of Europe. Thank you very much for waiting, for your patience, and we will hear your presentation now.
Yes, hello, ladies and gentlemen. I hope you can hear me.
Mr. Portney.
And thank you very much to the European Foundation of Human Rights for your kind invitation. Just to briefly present myself, so I'm the Secretary to the Committee on Legal Affairs and Human Rights of the Parliamentary Assembly of the Council of Europe. So in my presentation, I will mainly focus on the legal aspects of the protection of national minorities in the Council of Europe. But I will also refer to the work of the Parliamentary Assembly and to the political context of the Council of Europe work in this field. As regards the work of the Committee on Legal Affairs and Human Rights of the Parliamentary Assembly, so the committee was in charge of the issue of national minorities from the very beginning, so from its creation in 1949 until 2013, when the competences concerning the protection of national minorities were moved to another committee. And so this area is now within the remit of the Committee on Equality and Non-Discrimination. So unfortunately, in the Legal Affairs Committee, we are not dealing directly with the protection of national minorities, but we are still in charge of these issues when it comes to the implementation of the European Convention on Human Rights. Because the Committee on Legal Affairs and Human Rights is following the problem of execution of the judgments of the European Court of Human Rights. It has been following this issue for the last 20 years. And in the scope of dealing with this matter, so there are many problematic judgments touching upon the issue of protection of national minorities. So I will also refer to some of these judgments in my presentation. So I will start first with a few words about the European Convention on Human Rights. And as you know very well, so the convention doesn't confer any specific rights on national minorities. However, I could say that when we look at the convention and at the case law of the European Court of Human Rights, we could find some ways to find a possibility to for national minorities to look for a kind of protection under the European Convention on Human Rights. So you probably heard about the judgment Gorzelik and others against Poland from 2004, which concerned Silesian Minority Association. And well, this judgment confirmed the previous case law of the court, stressing that the states parties to the convention it cannot be said that they are obliged by international law to adopt a particular concept of national minority in their legislation. So there is no provision in international law which would oblige a state to define specifically national minority in its legislation, or to introduce a procedure for the official recognition of minority groups. However, the court referred to the existing documents on the protection of national minorities, and it reaffirmed that this protection is necessary for the stability, peace, and democratic security in Europe. So I would now move to a couple of judgments concerning persons belonging to national minorities. And first of all, we can see that in some situations the court recognized somehow the right to cultural identity of persons belonging to national minorities. And this was firstly done in the context of cases concerning Article 8 of the Convention, so the right to protection for private life. And since there have been some cases concerning the question of the lifestyle of gypsy families, the court dealt with this issue, in particular in a case against the United Kingdom, Chapman. It recognized that the question of their lifestyle, so in particular the fact that they wanted to park the caravans on their property, fell in the scope of the protection of the private life. And the court considered that this tradition of living in caravans was an integral part of ethnic identity of gypsies, and that states have a positive obligation to facilitate them their way of life. So through this situation, the court recognized that the lifestyle of some national minorities can fall in the scope of Article 8 of the Convention. More recently, a similar situation was considered in a case concerning eviction of gypsies in Bulgaria. So it was a case Jordanova and others against Bulgaria, and the court also found the violation of Article 8. Also, the issue of identity cards was examined in the context of the collapse of the Soviet Union. For example, in Moldova, there was a case concerning an applicant who wanted to have his Romanian ethnic origin recognized in his ID. After the collapse of the Soviet Union, and the court recognized that the ethnic identity constituted an essential aspect of his private life. So we can see there is a way to have his or her ethnic origin recognized by the court under Article 8 of the Convention. Another article of the convention, which is also very important for the protection of national minorities, is Article 9, guaranteeing freedom of religion or belief. But I'm not going to go into details here because it's less relevant. However, I will refer to Article 11 of the Convention, which guarantees the right to freedom of association and peaceful assembly. So this is a very important article in the context of the protection of national minorities. Well, I already referred to the judgment Gorzelik against Poland, in which there was no violation of this article, but in a few other judgments, the court found violations of the right to freedom of association in the context of cases concerning national minorities, especially in Greece and Bulgaria, and also concerning some minorities living in these countries. So one of the most famous judgments in this context is the judgment Sidoropoulos and others against Greece, in which the Greek authorities refused to register an association promoting the culture of a Macedonian minority living in a specific area in Greece. And the court found a violation of Article 11. As regards the execution of this judgment, it was examined quite quickly by the Committee of Ministers, which is responsible for supervising the execution of the court's judgment. So many people complained that the Committee of Ministers didn't pay enough attention to the implementation of this judgment. And in fact, further problems appeared with the implementation of some other judgments concerning Greece and concerning the Muslim minority, which is recognized on the basis of the Lausanne Treaty of 1923. Well, in fact, these are Turkish authorities, but according to the diplomatic language, we refer to the Muslim minority and we refer to the Treaty of Lausanne. So between 2009 and 2010, the European Court of Human Rights delivered a couple of judgments, starting with the judgment called Bekir Usta versus Greece. So there are at least 4 judgments concerning non-registration of Muslim minorities associations in Greece. And the court found a violation of the right to freedom of association. And these judgments are now pending before the Committee of Ministers, which supervises the implementation. And so they have been pending for over 10 years, which is becoming very problematic from the political point of view. So there have been some very strong decisions and resolutions adopted by the Committee of Ministers, which called Greece to recognize these associations and to allow their registration. But unfortunately, there was no progress in these cases. So the Greek jurisdictions refused many times to register these associations. And in some of these cases even went to the Supreme Court in Greece, but no solution has been found so far. So despite the judgment of the European Court of Human Rights, there is still no recognition of these associations at the national level. So this shows that this judgment touches upon political issues in Greece. as regards linguistic rights, we can also conclude that there are some ways under the European Convention on Human Rights to have them protected. Well, the convention is very specific on the rights of people who are arrested and need to be brought before the court. So it's a situation covered by Article 5, Paragraph 2 of the convention, which knows that the person who is arrested needs to know the charges in his or her own languages, and also under the right to defense, Article 6, Paragraph 3A of the Convention. So everyone who is accused in criminal charges needs to know the charges and needs to have an interpreter. But as regards more general issues, especially the issue of surnames and forenames, it's more problematic. So in general, we could say that according to the case law of the court, the question of the spelling of a surname or a forename falls in the ambit of, again, Article 8 of the Convention, right of protection of private life. But there is some margin of appreciation for the state. And the case law of the court was here quite contradictory. So there was one case against Turkey, Güzel Erdaguz, in which the applicant of Kurdish origin complained about the wrong spelling of her first name. And then the court found that indeed there was a violation of Article 8, but it found so because the law was not precise enough on the spelling requirements. A bit later, there was another case concerning a similar issue against Turkey, and the court didn't find a violation of Article 8 because it agreed with the Turkish state that the applicant was not allowed to use some characters which didn't exist in the Turkish alphabet. So unfortunately, there is the protection of the spelling of surnames and forenames is very limited under the convention. What is also important for the linguistic rights of minorities is the protection under Article 10 of the Convention, which guarantees freedom of expression. So, for example, there have been some cases concerning access to media, and again, against Turkey, there was a case in which the court found a violation of Article 10 because prisoners in Turkey didn't have access to some newspapers in Kurdish, and they were of Kurdish origin, so they were not allowed to read newspapers in their own language. So it was a violation of Article 10. But to conclude, as regards the protection under the right to private life, freedom of religion, and freedom of association and assembly, this protection is always very limited because the state keeps a wide margin of appreciation. So the convention contains specific provisions which allow for the state to limit these rights. And so especially this is there must be there's a requirement that that the limitation of the right must be guaranteed by law and has to be proportionate to the legitimate aim, which is usually which is specified in the convention, and usually a legitimate aim is national security public order or even the protection of the integrity of the territory of the state when it comes to Article 10 of the Convention. As regards other rights protected by the Convention and its protocols, and which are important to national minorities, of course, the right to education is very important, and it's guaranteed in Article 2 of Protocol 1 to the Convention. Well, in general, the court said that this right doesn't cover parents' linguistic preferences, but the case law of the court was more flexible in this respect. So, for example, in a famous interstate case, Cyprus against Turkey, the court found that there was a violation of this article because the Greeks living in northern Cyprus didn't have access to, couldn't use the Greek language in secondary schools. Also, there was a Turkish case in which the court found a violation of the convention because there were no optional classes in the Kurdish language at universities in Turkey. And one of the most important and recent cases is a case, Katan and others, concerning Moldova and Russia, and more specifically the Transnistria region. In this case, the applicants complained about the impossibility of using the Latin script in Moldovan language schools in Transnistria. And the court found a violation of the right to education because of this impossibility. And from the political point of view, this case is very problematic because it concerns Transnistria. It concerns the responsibility of Russia. And as Russia doesn't recognize its responsibility for the facts that occurred there, the execution of this judgment is very problematic. So it raises several political questions. Another important provision is, of course, the provision of concerning the right to free elections, so Article 3 of Protocol 1 to the Convention, so it's of course public. Of course, participation in public life is very important for persons belonging to national minorities. There have been some interesting cases. So one of them is the case against Latvia, Podkolzina, in which the applicant was not allowed to present herself as a candidate for parliamentary elections because of insufficient knowledge of the Latvian language. And the court found that it was in violation of Article 3 of Protocol 1. As regards similar situation, we have a very famous case, Sejdic and Finci, which against Bosnia and Herzegovina, which also concerns the impossibility for the candidates to stand for elections. But this case concerned presidential elections, which are not covered by Article 3 of Protocol 1. However, as Bosnia had ratified Protocol 12 to the convention, which provides for a full prohibition of discrimination, the court applied this protocol in this case and found a violation of Protocol 12 because the applicants who were of Jewish and Roma origin couldn't stand for presidential elections in Bosnia and Herzegovina. And here again, we have a situation which is very problematic from the political point of view, as the impossibility to stand for election results not only from the constitutional and the electoral legislation of Bosnia and Herzegovina, but it results from the Dayton Agreement. So there is an international agreement. So the situation is very problematic, and the national legislation in Bosnia and Herzegovina hasn't been changed for over 10 years. This judgment is being discussed by the Committee of Ministers as it was non-implemented, so there was no possibility for the applicants and people in similar situations to stand for elections. So we can see there are some ways under the European Convention on Human Rights which can allow applicants belonging to national minorities to stand for their rights. However, this is very limited. And as regards the work of the Parliamentary Assembly followed the issue of the protection of national minorities from the very beginning, and in particular, it was it called for an adoption of an additional protocol to the European Convention on Human Rights many times, and following one of its resolutions, which was adopted in 1993. The Framework Convention on the Protection of National Minorities was adopted. However, in the opinion of the Parliamentary Assembly, the existing instruments for the protection of national minorities, so the Framework Convention and also the European Charter for Regional or Minority Languages, are not sufficient. And the Parliamentary Assembly again called for the adoption of an additional protocol to the European Convention on Human Rights. So last time it was in 2012 on the basis of a report of the Committee on Legal Affairs and Human Rights. So a rapporteur from Romania, a Hungarian-speaking rapporteur, Mr. Frunda, prepared a report in which he insisted on adopting an additional protocol to the ECHR. So one of the arguments being used in favor of such a protocol is the possibility for persons belonging to national minorities to seize the European Court of Human Rights. And it's not only for persons, but mainly for groups. So it will be important as for national minority groups to seize the European Court as such as national minority groups. And that is why also the Committee on Legal Affairs and Human Rights insisted on adopting such a protocol, because it would also be important to define a national minority in such a protocol, and to better to define more precisely the rights of national minorities persons. So in particular, the political rights, also the cultural rights, including the right to cultural autonomy, to preserve national identity, and also the linguistic rights. So so the assembly approved this idea of having an additional protocol, and it was in for the last time it was in March 2012 in resolution 1866. However, this proposal was not followed once again, and the Committee of Ministers, which has an obligation to reply to Assembly's recommendation, clearly stated that the existing instruments, the Framework Convention and the Charter on National on minority and regional languages are sufficient. So there's nothing new as regards legal instruments concerning protection of national minorities in Council of Europe for the moment. Issues concerning political context related to some specific problems of national minorities are followed by the Parliamentary Assembly and in particular the Committee on Non-Discrimination and Equality. Recently there was a new report by Serbian rapporteur Elvira Kovac on preserving the rights of national minorities, and this report was approved by the Parliamentary Assembly last April. So there was a resolution 2362 adopted, and this resolution confirmed that there are some problems in the implementation of the Framework Convention. In particular, there is a problem with not necessarily with the existing national laws, but in particular with the implementation of national laws. And it was also stressed that the COVID-19 pandemic had a very bad impact on national minorities, and especially as regards associations defending their rights. So the Assembly called on states to once again to follow the Framework Convention and to take the necessary measures to implement it. And it also referred to the issue of Protocol 12, which prohibits discrimination and which was unfortunately ratified by only 20 member states of the convention. So once again, the Parliamentary Assembly called on member states of the Council of Europe to ratify Protocol 12 to the convention. Another interesting avenue is the possibility to seize the Venice Commission, so an expert body of the Council of Europe, a body composed of experts on constitutional matters. And the Venice Commission reacted quite a few times on draft laws concerning national minorities. So it did so in particular with respect to some language laws in Ukraine, and recently with respect to the legislation on languages in Latvia. And the Parliamentary Assembly is quite powerful in this respect because it can seize the Venice Commission. So very often if there are news regarding new legislation which might be problematic, for example, from the point of view of protection of national minorities, the Parliamentary Assembly can act quite quickly by requesting the Venice Commission for opinion, and the Venice Commission is also quite quick in analyzing the questioned legislation. So this is an interesting tool which can be used by NGOs complaining about some new draft laws. But of course, the opinions of the Venice Commission, they are, even though they might be very useful, because they refer to the existing standards on human rights at international level, not only at the Council of Europe level, but also at the international level. But these opinions are not, they have no binding effects, so they contain only recommendations. So I will stop here. Just wanted to conclude by saying that, in my view, well, there might be some evolution of the case law of the European Court of Human Rights in the future. So I think it's interesting to follow what the court says, especially under Article 8 of the Convention or Article 11. But of course, this protection is very limited, and unfortunately, there is no political will for the moment to add a new protocol to the European Convention of Human Rights, which would be devoted to national minorities. So thank you very much for your attention.
Dėkojame Jums už visą informaciją suteiktą apie tai, kaip.
Thank you very much for all the information, how the institutions and the Council of Europe and other institutions could help in dealing with the problems of national minorities. We don't really have time for discussion. I would like to thank all the speakers. If you do have any questions, you can either ask and write to the chat, or just give a sign and ask your question if you have an urgent one. So far, very briefly, I will tell you that in summarizing, just to focus on Dr. Hanna Vasilievich presentation. What was interesting to me when comparing the situation with Czech Republic and Lithuania was about automated or online census. In Lithuania, we have an example as well. We would like Lithuania to follow this, the steps of the Czech Republic. We still have the situation that this year the census, population census, is ongoing, but it is not necessary to provide your nationality, because this information is collected from national register, but not all citizens provided the nationality there, and there are lots of issues whether real data will be taken into account, and how can we really get the real data if the data is not correct. So there was a wish to have a questionnaire, but it was not compulsory, and it was only in the Lithuanian language. So thank you very much for your insight, for your thought. So you provided information how it's being done in the Czech Republic, where it was online and was accessible in paper form, and it was actually translated into 7 languages. That is a great and followed example. Any other questions from the speakers? Any feedback? Who would like to add something? Unfortunately, we don't have Danuta Šeinicka, who puts quite a lot of good insights that, according to the observations of Birutė Sabatauskaitė, the Ombudsman of Equal Opportunities, that one should have equal opportunities for school graduation exams. And as Mrs. Šeinicka mentioned, unfortunately, the national minority languages, native languages are not qualified, are not considered with the exam results, because these are not compulsory exams and they are of a school lower level. These are not state exams. And this gives some concern, because this is inequality when entering the universities. These national minority representatives have an additional language. They cannot use the results of that language when they want to enter higher education institutions. This makes the opportunities small.
Dalykas, kad vis dėlto tos galimybės būtų lygios, nes tas ugdymas.
So these opportunities have to be equal, because education is very important. They increase human resources, as Mr. Šeinicka said, and the Lithuanian Social Science Center representative in their insights.
Tautinių mažumų kalbų mokymas iš tikrųjų
stiprina. The learning of national minority languages, the studying of them, strengthen human resources. So then we have wider opportunities to propose to the state and the employees. And Mrs. Elżbieta Kozborska also spoke about that the state has to focus on private sector incentives in promoting the employability of national minorities. If there are no other questions, comments, anyone? Mrs. Agnieszka Szklana said that she can provide to all those who are willing a list of cases she quoted and decisions she quoted. I do hope that others can exchange contacts as well, and if you wish to do so, please do so. If you want to get into the specifics of the presentations. I would like to thank every speaker for your participation, for the time, for your wishes. For 10 years is a very important stage, and we're continuing our work. Thank you very much for appreciating it. Thank you for participation. The recording of the conference will be accessible to the public, and we do hope that for Lithuanian and foreign organizations, they will be interested in a broader perspective, will not look into only the expectations of national minorities as something strange and not possible to implement, but as the equal rights and opportunities And national minorities will not be considered as a threat, but as something that we strive for, as a treasure, cultural and economic maybe, because of human resources and talents, and as ambassadors for local community and in the international context. Thank you very much for your participation. After this conference, we would like to publish some information, so we will get in touch with all the speakers. That will be intended for academic institutions and organizations that work every day in the area of national minorities. So it is as relevant and practical as possible. So all presentations really made this information very relevant. So thank you very much for your time, and I do hope I'll see you next time.